May I mention item number 13, my lord? 13 of the consent of the other side, my lord. May I pray the item may come up on 10th of April, my lord.
Please.
10th of April.
Yeah, Your Lordship, my lord, I was the lowest bidder. Even then, my lord, depriving me, they want to retender the matter. Already issued, last date is 21. So it may kindly be listed tomorrow. We have already filed a case yesterday.
Last date is when?
No, tender opening date is 21, which has been sought to be issued. So before that order should go, we have already filed. It may be listed tomorrow.
Okay.
Hello.
My lord, this matter may be listed for admission, my lord. On 20th, my lord.
20?
20, my lord.
What?
My lord, this is regarding permission for liquor shop, and here notice of motion was issued, but thereafter it was not listed.
Okay. We'll have it on 21st.
Yes.
My lord, with the consent of petitioner, I beg to mention item number 5. As senior colleague is out of session today,
Who's the senior?
Mr. S.R. Rava.
BTC.
Yeah.
Who's the petitioner?
That may be fixed, lordship. I am the petitioner.
Okay, heard Mr.
A. Sharma,
A.
lordship.
Sharma.
I know it may be fixed on 25th March.
What request made on behalf of the first proper the standing council BTC? When do you want?
25th March. 253.
Deeply obliged.
May I please, your lordship, my lord? My lord, I have prayer for listing of a case, my lord. This was supposed to be listed in the month of January, my lord. Matter pertaining to, my lord, appointment to the post of revenue Sharistadar, my lord. Lordship will kindly fix this case on 24th of March, my lord.
11,
Monday.
26.
26.
Yeah.
My lord, my lord. Deeply obliged.
May I please, your lord? Lordship, I beg to mention on read petition, lordship. Matter was listed on 14/3, lordship. Your honor was directed to list after 1 week on motion matter, lordship.
Oh.
So matter may be listed on 21, lordship. Friday.
Okay.
Another same prayer, lordship, same matter.
Lordship, with the consent of the other side, I beg to mention item 29 of today's daily list. The consent has been taken from the respondent side. The engaged counsel 29.
Okay.
The engaged counsel N. Sharma is presently out of station, so seeking time for today.
For the petitioner.
Yes, Your Honor.
On request made on behalf of Mr. N. Sharma. It's the matter after.
3 weeks. Kindly notice.
May I please, your lordship? Lordship, in item number 23, we have filed the affidavit in opposition yesterday.
Okay.
So we need to bring on record. So lordship, today the matter may be listed with the records.
You want it called today?
Yes, calling for the records.
Okay.
Obliged.
Item 31 and 32 of supplementary list, motion. Sorry, admission.
May I pray for some for time being, your lordship? He's on legs in Tata court.
He had already completed his arguments yesterday. And in any case, it was.
I've already made my mind clear
But-
yesterday.
but-
But so far as the interim is concerned, I'd like to modify it. Insofar as the respondent number 5 is concerned.
But
Leaving-
on that, my lord, because my learned friend had made substantial arguments on merits, I'd like to respond to that. Your lordship will allow me some time. So far as continuance in respect of respondent number 5, because the basic facts itself have not been placed, the relevant tender clauses have not been placed. A picture has been given that the allotment to respondent, selection of respondent number 5 is out and out illegal, which is not correct. The basic, my friend has made elaborate arguments, my lord, on merits.
Daughter, yesterday, the argument, whatever it is, that was just trying to get to know the facts. All
Well-
right, it's not a question of arguing on the writ petition or any other. Just getting to know some facts.
My lord, I just, because subject to your lordship and my learned friend, what the Ahmedabad asset, we are not Ahmedabad asset, so your lordship can modify to that extent. Ahmedabad asset, we are not Ahmedabad asset.
there cannot be any blanket, my lord, stay order. So let the Ahmedabad asset, my lordship, modify that they can go ahead with Ahmedabad asset. Secondly, so far as other bidders are concerned, we are not concerned about the other bidders. That also they can go ahead. There is absolutely no
That's
problem.
why.
So only
the
the
respondent five.
five. Now respondent five, there has to be response so far as the main affidavit is concerned. This is.
We have not filed any main
No,
affidavit. There is
I
an
know.
application for
No,
vacation.
I understand. So number three is that we have filed an application for amendment. What I am humble prayer is that my lord will allow this amendment subject. If he has some objection, then I have to argue on that. If he has some objection in the amendment application, then I have to show that whether nature and character of the whole case changes if your lordship allows the amendment. That I have to argue. If my learned friend has some objection in allowing the amendment. That's number three, my lord. So, my lord, your lordship will hear this matter. And by next week, if there is some urgency in this matter, your lordship will hear it.
We'll hear
On
it.
Monday or
We will
Tuesday, your
hear
lordship
it.
will hear it.
But notice who appears for R five in the main writ petition. Have you filed your affidavit?
Not yet.
Okay. Then your amendment application is here?
Yes, it's there.
Okay, that will.
756.
Seven,
And
five,
what happens to ballot?
First,
we have-
let us consider the IA
Yeah.
for petition.
Man, that is what I.
I'm sorry, my lord.
I'll first consider the IA
Yes, yes.
for vacation or modification. whatever.
Yes.
I don't want to waste time
Man,
because I've already made my mind clear. That so far as Ahmedabad and other units of Assam are concerned, I'm not interested. But so far as respondent five is concerned, they will continue.
But on that, I would like to make a few short submissions because the IA we have filed for vacation. 2 or 3 aspects I would like to highlight before your lordship. And after that, your lordship will take a call on because the IA for vacation was filed long back, my lord, 2 weeks back. And the application for amendment has come only yesterday. So this IA for vacation has to be considered and some order has to be passed in that. So on that matter, I'd like to make a few short submissions because my learned friend has made elaborate arguments on merits. I did not want to trouble your lordship on the merits, but a few aspects. Number one, rightly or wrongly, the work order was issued on 14/1/2025.
Right.
Your lordship has seen, my learned friend had pointed out before your lordship, that the mobilization period allowed is 75 days. So if your lordship starts counting from 14th of January, already 64 days have passed. And the interim order that was passed, your lordships normally do not pass a status quo ante order. Had this aspect been brought to the notice of this honorable court, that the work order has already been issued. And in fact, a contrary submission was made that work order has not been issued, which I had pointed out from page 31 of the IA. It's a submission recorded on the mouth of the petitioner that no work order has been issued. A process has started for a lot. So based on that submission, the interim order was passed. And what is the interim order? That work order should not be issued. However, the work order was already issued a month back. On that, that is my first submission. Second submission is, the statement made, if your lordship will kindly come to the IA for amendment that has been filed.
IA for amendment.
Amendment.
This amendment, if you have an objection,
No, we are not objecting.
I'll give you time for making the objection.
Your lordship will, I am only on the, as has fallen from your lordship, I am only on the application for vacation of the interim.
Correct.
I just wanted to point out the statement made on oath in the application for amendment. Your lordship will kindly come to page 10 of the IA number 756. This is the application for amendment.
Oh. Yes.
First, your lordship will come to para 6.
But just 2 minutes, I will be back.
Para 6, man, at page 10. that the applicant had stated in the writ petition that it has come to his knowledge that notification of award dated 14/1/2025 has been issued to the respondent number 5. So it was within the knowledge when the writ petition was filed. However, the said order dated 14/1/2025 was not in possession of the applicant and as such has now filed an additional affidavit to bring on record the order dated so and so after vacating application being preferred by ONG. Then, my lord, para 7, last sentence. The notification of award dated 14/1/2025 inadvertently not challenged as the same was not in possession. By these two statements, they are admitting that it is a defective writ petition they have filed. On a defective writ petition, there was an interim order passed. And if your lordship kindly sees the amendment that they are seeking, paragraph 8, they are seeking amendment of prayer C to the extent of adding. Your lordship will kindly see what is the amendment that they are seeking. A writ in the nature of certiorari shall not be issued to set aside quash impugned online lists published on so and so at 4:30 p.m. by ONGC notifying the bidders in order of so and so. Respondent number 5 was found to be L1 and oblique or the consequent notification of award dated 14/1/25. This is the portion they want amendment. This is the main prayer. Today, there is no prayer for stay of the 14/1/2025. They are not even making an interim prayer even in the amendment application. So how on earth can a work order for which stay is not even being prayed for, how can that be passed even? And that work order was issued more than 1 month before the interim order was passed. And that is why, my lord, if your lordship comes back to the writ petition, what they had, the mischief that they had done was this. Page 31. Page 31 of the writ petition. That is why I am saying that in this writ petition, my lord, normally I don't harp on the conduct of the writ petition. The conduct is very important. Your lordship will kindly come to para 31, page 31. What is the statement on oath made in the writ petition? Eighth line from the top. Now, pursuant to the opening of the financial bid in respect of the NIT dated 6/6/2024, it has come to the knowledge of the petitioner that notice of award, because the moment say notification of award, as per 33.2, it is a binding contract. Clause 33.2, which I had placed yesterday, says that notification of award constitutes a binding contract. So therefore, in a very fine way, subtle way, instead of using the word notification, they use the word notice of award, and thereafter, my lord, your lordship will continue. Has been issued to the respondent number 5 on 14/1/25, but no work order or contract has been signed with the respondent number 5. It's a out and out incorrect statement on oath. And
No,
based,
contract has been signed?
no, because once the notification of award, which if your lordship kindly comes to that clause, what is it? Page 80 of the writ petition. Clause 33.2, your lordship will kindly see, the notification of award will constitute the formation of the contract. Page 80, at the top. The notification of award will constitute the formation of the contract. So, two things that were not disclosed to this honorable court is that the work order notification of award was already issued on 14/1, and that this notification of award constitutes the formation of the contract. On the contrary, the submission that was made, I have pointed out yesterday. If your lordship sees the order, what is the submission made before this honorable court to take the interim order one? If your lordship, page 30 of I.
30 of
I.
AA.
The last sentence of IA number 666, 666 of 22. This is the interim order itself that I am pointing out to you. Page 30, line about 9 from top towards the right hand side, your lordship will find a sentence starting, however. towards the right hand. However, it is submitted that the respondent authorities are proceeding to allot the tender in respect of the respondent number 5. Mr. So-and-so therefore submits that interference of this court is necessary to restrict the process undertaken by the respondent authorities for allotment of tender in respect of the respondent number 5, who is not clearly qualified in terms of the eligibility criteria provided. So submission that was advanced based on this statement, firstly, notification of award is not placed on record. Secondly, they say that it is a notice of award. Thirdly, that clause 33.2 is not even placed. And fourthly, this submission, contrary submission is made that the process has been started for allotment of the work. So based on these submissions is the interim order that has been passed. Now, at this stage, assuming your lordship, because there is no prayer for stay of 14.1, even in the amendment application, normally what happens? When an IA is filed for praying for amendment, assuming we do not object and your lordship allows the IA today itself, what is the procedure? They will have to file an amended writ petition. So till that amended writ petition is filed, the writ petition continues to be defective. Even in the defective writ petition, there is no prayer for stay of 14.125. So if your lordship essentially continues the interim order, what happens is a futile order, not to allot the work order, because work order has already been issued. A futile order would be continued. And your lordship is aware, Ballot, the proposition of law is very well settled, that while exercising jurisdiction under Article 226, your lordships do not issue futile writs, orders or directives. So on the interim order itself, this is my submission before your lordship, that it looked at from any angle, it cannot be continued. And on the merits, a very strange kind of submission has been made that he is not qualified. One very vital clause has not been even placed before your lordship. On the merits, I won't trouble your lordship too much. How he has conducted himself and what we have done. If your lordship will kindly come to page 73 of the writ petition, just one clause. Raj? Page 73, 24.2.1. During evaluation of bids, purchaser may at its discretion ask the bidder for clarifications or confirmations or deficient documents of its bids. Your lordship will kindly note this. The request for clarification and the response shall be in writing, and no change in the price of substance of the bid shall be sought or permitted. What is not permitted is the price cannot be changed. Otherwise, deficient documents can be taken. The reason is very simple, Ballot. If your lordship comes back to page 57, these clauses were not even placed. So every tenderer has to submit something called a bid matrix. Clause 8.2, your lordship will kindly note this one. Submission of bid matrix duly filled in to reconfirm compliance with tender requirements. Bidders should submit the bid matrix as enclosed with the bid document duly filled in so as to reconfirm compliance with each of the requirements of BEC and other important conditions of the tender. Each such confirmation should be clearly stated in the bid matrix, indicating confirmed or not confirmed. So this bid matrix is part of the NIT. That has not been annexed to the writ petition. This is like a form, my lord. In fact, I can give a sample. A bid matrix or extra copy. Every tenderer has to this is the bid matrix that every tenderer has to submit. So it's a form. It forms part of the tender document. On the right hand side, your lordship has seen blank in the chart. So every tenderer has to say, I fulfill this criteria, confirm or not confirm. So when it came to the respondent number 5, they are right in saying that he originally submitted, he wrote in this that he confirms that he fulfills the experience criteria. But he submitted a certificate which pertains to O&M. So we asked for a clarification, just the way we asked clarification from all the 20, there were 24 bidders, we asked clarification from all 24. With respect to the respondent number 5, we asked him to clarify that you have said that you confirm, you fulfill the criteria, but the certificate that you have given is something else. So he, in conformity with the eligibility criteria, he submitted a certificate. Against that certificate, they raised another complaint. We considered the representation and took a decision again. They said that he is submitting a experience certificate for so-and-so field, some Haldia field or something, Halisa field. But that field has been closed down. So how can he have that experience? So by coincidence, that Halisa field happens to be our own asset, ONGC's own asset. So we checked up and we found that the lease, mining lease for that Halisa field has been extended by 20 years. So we, after confirming that he fulfills that, only after that, we decided to totally him for the simple reason, the price difference of the respondent number 5 and the other tenderers is huge, running into several crores. He is not only the lowest, we end up saving a lot of money. So it is in these circumstances, and your lordship will see the fun. If your lordship kindly comes to the writ petition again, same clarification, even he was allowed to. If your lordship will kindly come to page 125 of the writ petition. Your lordship is aware of the settled proposition that if you have taken the benefit of a particular clause, you cannot subsequently object. It is hid by the doctrine of approbation and reprobation. Page 125. Your lordship will see the date 26/9/2024. Your lordship will note the date. It is addressed to Rajiv Hazarika, the writ petitioner, and subject clarifications, confirmations, deficient documents, etc., for hiring of scrapping winch for Assam. And if your lordship kindly turns to page 127, your lordship will find what is it that we asked for. These are fundamental eligibility criteria. Turnover figures of 21, 22, 22, 23. And number B, whether net worth is positive or negative. The reason is very simple. He had, yesterday a submission was made that these documents we had already submitted. What he had submitted was this document at page 121. Your lordship will kindly note the date of this document, 15/7/2024. This is prior to the date of the NIT. Accepted. But what does it say? As per records produced, your lordship will just note this, as per records produced and explanations given to us. So some records are produced and explanations, obviously it is the petitioner who gave the explanation to the chartered accountant. To us, it is certified herewith that Sri Rajiv Hazarika, son of so-and-so, has positive net worth for financial years ended on 31/3/2022-2023. Now, once we asked for this clarification, he gave this document. If your lordship will kindly come back to the IA. Page 32 of the IA. He is saying that he did not change the document. He did not submit any new document. Your lordship has seen the date of asking for clarification is 26/9/24. Your lordship will kindly see the contents of this document. We have verified the audited financial statements. Your lordship will kindly note this because this is the requirement under the NIT. I'll place that clause. Earlier he says that we have verified some records and explanations given. Now the chartered accountant modifies the certificate. We have verified the audited financial statements and other relevant records of Rajiv Hazarika so-and-so and certify the following. What is the first certification? Rajiv Hazarika is not liable for statutory audit as he has a sole proprietorship concern and not a company. Since it is not a company, it is not required to prepare consolidated financial statements. Number 2, that as per latest audited financial statement, net worth of Rajiv Hazarika is positive. As per what? Audited financial statement. Because this is the requirement under the NIT. And your lordship will kindly note the date. 1/10/2024. The date for asking the clarification was 26/9/24. And this is a fresh document he gets and he submits it. Because The reason is very simple. Page 94 of the writ petition, your lordship will find the tender clause. And very conveniently, all other clauses that are convenient for the petitioner were placed, but anything that goes against him were never placed. That hide and seek business, Supreme Court has repeatedly said that no, when you come to a writ court, be frank and honest. Don't lie to the court.
Yeah.
Page 94. At the top, your lordship will find turnover of bidders. After that, serial number 2, net worth of bidder, positive. Thereafter, next sentence, your lordship may skip. Just after that, the turnover of bidders to be considered for evaluation shall be average turnover, etc., as brought out at note 4 below. And thereafter, subject to provisions under second paragraph of note 1A, net worth shall be based on latest or audited consolidated financial statements of the bidder with all its subsidiaries. So earlier one is based on some vague records and explanations given by him. So that did not comply with the mandatory eligibility criteria of turnover and net worth. So he has himself taken the benefit of that clause 24.2.1 of submitting a clarification and submitting a fresh document. So would it lie in his mouth to complain about someone else? Because that is what the Supreme Court says, that if you have taken the benefit yourself, you cannot object in respect of someone else. So all these facts on merit were never brought to the notice of this honorable court. And yeah, if your lordship kindly comes to 95 also, that will further clarify. Subclause C. A certificate from statutory auditor in respect of positive net worth on the basis of audited consolidated financial statement. He had not submitted it. We could have, just like he is saying that we should have rejected respondent number 5. In that case, we have to reject him also. If that be so, if taking the clarification is wrong. That is why, till they submitted the representation, there was no whisper about clarifications being sought, because he has himself taken the benefit. After the all these clarifications were sought, they found that here is a bidder who has submitted a bid for 10 and he has quoted the lowest price. Immediately, price bids were opened. Once they found out the price, they realized that 10 out of the 38 will go to this person. That is when they jump and start submitting representations. And your lordship will kindly see the representation that they have submitted, 132 of the representation. Not a whisper about all these things. This is the first representation submitted by Rajiv. They submit object to various other tenderers also. First paragraph is very important. We sincerely express our satisfaction and appreciate ONGC for its dedication to maintaining transparency in its tendering process, particularly through the CPP platform. These initiatives greatly contribute to a fair process of allowing bidders to review the credentials of their competitors, thereby ensuring equitable environment. So they are admitting that it has been a very fair and transparent process. Now, with regard to the respondent number 5, what is their objection? Your lordship will say. South Asia Consultancy. The bidder has submitted an experience certificate claiming operational work in the Halisa field from March 21 to February 23. However, according to data available on the DGH website, the validity of this field expired on 29 January 2018. So therefore, they were saying with no subsequent renewal information. Therefore, it is clear that South Asia Consultancy could not have conducted any operational activities in this field beyond its expiration date. The submitted documents appear to be fabricated, and we request a thorough investigation to verify the legitimacy of their claimed experience. So once this representation was submitted, what we did was, we have stated in the IA. First, my lord, if your lordship will kindly come to the IA for IA filed by us. Page 69. your lordship will find this is a document of 31/8/2020 at the top. Government of Gujarat had extended in exercise of powers conferred under Rule so and so Petroleum Natural Gas Rules 1959. The government of Gujarat is pleased to regrant a mining lease for crude oil and natural gas as per following. Halisa, name of mining lease, Halisa, effective date 31/2018, term of mining lease 20 years, and name of the lessee is ONGC. It is our own asset. So we verified. When they objected, we again verified that, oh, all right, there might be some truths, let us cross-check. And after that, when we found that it is a legitimate certificate that he has submitted, so why should we oust him? Because there is a huge difference in rates. And it is the same benefit that were given. It is our pleaded stand, my lord, at page 11 in the same IA. Para 9. That the applicant state that the respondent number 5 had confirmed in the bid matrix against BEC clause so and so towards meeting the experience criteria, but had submitted documents for providing operation and maintenance service 1 of work over rig for ONGC. Hence, as per clause A and clause 24.2.1 of the tender document, the respondent number 5 was asked to clarify and submit work experience document meeting the requirement of the BEC. ONGC issued the letter to the respondent number 5 on 26/9. Same date, petitioner was also issued. It is relevant to state and point out herein that 24 bidders quoting bid for Assam asset, including the writ petitioner, were given opportunity to submit the clarifications, confirmation, deficient documents as per tender document in the first round. We have uniformly applied the yardstick. And it is based on his certificate that 10/1/2024 subsequent certificate of turnover that he was selected. So how can he, having taken the benefit, how can he now turn back and say that you could not have done it for him, but I have, all right, I have taken the benefit. All those, I can place those judgments, man. Settle proposition. Doctrine of approbation and reprobation. If you have taken advantage of a clause in a document, you cannot turn around. And based on this, now the situation as it stands at the cost of repetition, your lordship will have to modify the interim order by staying 14(1). There is no prayer for stay of that. If your lordship sees the amendment, assuming your lordship allows the amendment application, and assuming he files the amended application, writ petition right now, in the next 5 minutes, even then, as prayed for, if your lordship sees the prayer made in the, and in fact, I have not been able to decipher the language. If your lordship sees the prayer in the IA for amendment, allow the present application and allow the applicant's petitioners to amend the memo of parties. Yes, all right, amend the memo of parties. Page 13 of the IA for amendment. This is a prayer which needs serious deciphering. A code expert will have to be brought in. Allow the present application and allow the applicant's petitioners to amend the memo of parties of the writ petition being WPC number so and so by amending the prayer C. Why do they need a? The prayer is not made in the memo of parties. Yeah, if I have understood in the last 30 years of my practice.
Prayer C. Yeah.
I have never seen a prayer being made in the memo of parties, at least in my 30 years of experience. So, rightly or wrongly, there is no prayer for amending the interim prayer to the extent of staying the 14(1)25. So, where is the, your lordship will not extend a futile order, a work order which was already issued. The interim order says that work order should not be issued. Now, on the face of this, my lord, in my respectful submission, yeah, they have been very fair to the extent of saying that Ahmedabad, obviously there is no challenge also. Ahmedabad and Assam, with respect to the other, there are
How many units are there?
total units 24. 10 has been allotted to him, so remaining 40. So those have to be, your lordship, 12, because 2 we could not allot because there was a tie in the price. So we have allotted 12 in respect of Assam and 14 in respect of Amitabh. Those, your lordship will, with greatest respect, my lord, your lordship will immediately clear. We have showing due deference, although there is no challenge. Showing due respect to this honorable court, we have not proceeded. But that your lordship will clarify so that we can start proceeding immediately. Because there also, my lord, mobilization period almost a month has passed. More than a month has passed. So far as this is concerned, my lord, in my respectful submit, your lordship will certainly examine, make it subject to outcome of the writ petition. But what interim order today? Even if your lordship extends the earlier interim order, that is an infractionous interim order because the work order was already issued. And there is no fresh prayer for stay of the 14-1. So looked at from any angle, my lord, if your lordships want me to respond to all the submissions made on the merits, I can carry on. If your lordship allows me half an hour, I can address on each of the issues. There is absolutely nothing in this writ petition. And most importantly, my lord, I would like to place one judgment on the conduct. First, what do? They make a tactfully, instead of using the word notification, they use the word notice. Thereafter, they say no work order has been issued. Thereafter, they make a submission as if work order has not been issued and the process has been started for allotting the work. If this kind of a conduct is resorted to, your lordship is aware of that famous judgment, K.D. Sharma. 2008, volume 12, SCC 481. Anasri. I am relying on 34, 36, part of 37, 38, and 39. When your lordship exercises the extraordinary jurisdiction, your lordship will not entertain such jugglery of words. Your lordship will not allow a litigant to play around with words for the purpose of misleading. The jurisdiction of the Supreme Court under Article 32 and of the High Court under 226 of the Constitution is extraordinary, equitable, and discretionary. Prerogative writs mentioned therein are issued for doing substantial justice. It is therefore of utmost necessity that the petitioner approaching the writ court must come with clean hands, put forward all the facts before the court without concealing or suppressing anything, and seek an appropriate relief. If there is no candid disclosure of relevant and material facts, or the petitioner is guilty of misleading the court, his petition may be dismissed at the threshold without considering the merits of the claim. Next, 36. A prerogative remedy is not a matter of course. While exercising extraordinary power, a writ court would certainly bear in mind the conduct of the party who invokes the jurisdiction of the court. If the applicant makes a false statement or suppresses material facts or attempts to mislead the court may dismiss the action on the ground alone and may refuse to enter into the merits of the case by stating, we will not listen to your application because of what you have done. The rule has been evolved in the larger public interest to deter unscrupulous litigants from abusing the process of the court by deceiving it. Then, paragraph 37, this judgment is quoted where it is said that writ petitions are decided entirely on affidavits. And then coming to 38, the above principles have been accepted in our legal system also. As per settled law, the party who invokes the extraordinary jurisdiction of this court under Article 32 or of a High Court under Article 226 of the Constitution is supposed to be truthful, frank, and open. He must disclose all material facts without any reservation, even if they are against him. He cannot be allowed to play hide and seek or to pick and choose the facts he likes to disclose and to suppress, keep back, or not to disclose, conceal other facts. The very basis of the writ jurisdiction rests in the disclosure of true and complete correct facts. Then your lordship may skip the next portion. Your lordship will come to paragraph 39. If I may pause here for a moment, my lord. Till K.D. Sharma was rendered, the apex court as well as your lordships exercising 226 jurisdiction always used to say that we will simply dismiss the writ petition. But this has become such a regular practice. In K.D. Sharma, this new principle as in 39 has been developed. If the primary object as highlighted in Kensington income tax is kept in mind, an applicant who does not come with candid facts and clean breast cannot hold a writ of the court with soiled hands. Suppression or concealment of material facts is not an advocacy. It is a jugglery, manipulation, maneuvering, or misrepresentation, which has no place in equitable and prerogative jurisdiction. If the applicant does not disclose all the material facts fairly and truly, but states them in distorted manner and misleads the court has inherent power in order to protect itself and to prevent an abuse of its process to discharge the rule nicety and refuse to proceed further with the examination of the case on merits. Next sentence is very important. If the court does not reject the petition on that ground, the court would be failing in its duty. In fact, such an applicant requires to be dealt with for contempt of court for abusing the process of this. Here is a case, my lord. Even now, when they file the amendment application, they are saying that they knew, but they did not have, were not in possession. And therefore, it was inadvertently not challenged. But your lordship will see the submission made in paragraph 8 of the, as recorded in the order. Your lordship will, with greatest respect, my lord, and with all sense of humility, I am making this submission. If such kind of conduct is allowed, your lordship will see a project of public importance. We need these scrapping winches to keep our wells going. Otherwise, the production itself might be affected. It might be hazardous. It might be unsafe. That kind of a project has been halted on the basis of incorrect statements, false statements, misrepresentation, jugglery of words. Whether your lordship will permit, and even otherwise, all that apart, there is no question of extending because it will be an extension of a futile order, which your lordships do not do while exercising jurisdiction under article. But therefore, my lord, without that your lordships do not issue futile writs, I am just giving the citation, my lord. S.L. Kapoor's judgment, famous judgment. 1980, volume 4 SCC, 379. And the relevant paragraph is paragraph 24. It's a very long paragraph. The relevant portion is at page 395. Paragraph 24 at page 395. The principle is that your lordships do not issue futile writs. Here, my lord, issue was whether natural justice needs to be followed at all, in all cases. There, my lord, the Supreme Court, in fact, line about 7 from bottom, on the extreme right-hand side, there is a sentence starting as we said earlier, as my lord got. As we said earlier, where on the admitted or indisputable facts, only one conclusion is possible, and under the law, only one penalty is permissible. The court may not issue its writ to compel the observance of natural justice, not because it is not necessary to observe natural justice, but because courts do not issue futile writs. So, if your lordship extends that interim order, it will amount to extending a futile order, because the order is not to issue a work order, which work order was already issued more than a month. And even looking at the balance of convenience, as it was pointed out by my learned friend yesterday, mobilization period was 75 days. 14th of January, we issued the work order. Already 64 days have passed. So out of those 75 days, only 11 days remain. So even looked at from balance of convenience, prima facie case, all possible angles. Even the interim order in respect of these 10, the respondent number 5, should not be extended, so that public interest will not suffer. And admittedly, nowhere your lordship will find any pleading that their rates are even competitive. We can give all those details. If necessary, we'll file an affidavit. There's a huge margin. We save a lot of money. And in any case, your lordship will kindly have a look at this one. He has bid for only 2 units. And at his instance, 10 units, can that be? That is another way of looking at it. looked at from any angle, this interim order ought not to be extended. And so far as the others are concerned, they have themselves admitted. So that's my submission. Let it be subject to outcome. Your lordship will hear it next week. No problem. We'll file our affidavit immediately. The same IA, we can put it in the form of an affidavit and we can file it. We have incorporated virtually everything. And in any case, my lord, the amendment is yet to be allowed. So by filing that IA for amendment, they are admitting that it is a defective writ petition they have filed. And even in that IA for amendment, there is no prayer posted.
That is one thing,
What is the defective? Word use defective, word use misleading. Oh, my please, my lord, I just want to give a reply. Your lordship put questions and I'll give a reply. Defective, misleading, submission has been made.
Yes,
Suppression.
judicial order.
You have argued. Let me point out that I never mislead or there is no suppression of material fact. Judicial order cannot be a suppression of the judicial order. That's a judicial. I'll show, my lord. Please look into it. What is the judgment? I brought the judgment, same judgment. I read the same judgment, which my learned friend has read it. What the judgment says in paragraph 38? There has to be suppression of material facts. Because your lordship doesn't go in legal issues only. Kindly see, my lord, what 38 says, and I will point out that we have never misled the court. We have never misled. Kindly see the same judgment at page para 38. See the para 38. K.D. Sharma's judgment, my lord. Kindly look into it, my lord. Just now, your lordship.
Oh, yeah.
Yes. See paragraph 38, my lord. The above principle has been accepted in our legal system also. As per settled law, the party who invokes the extraordinary jurisdiction of this court under Article 32 or a High Court under Article 226 of Constitution is supposed to be truthful, frank and open. He must disclose all material facts without any reservation even if they are against him. He cannot be allowed to play hide and seek or to pick and choose the fact he likes to disclose and to suppress, keep back or not to disclose, conceal other facts. The very basis of the writ jurisdiction rests in disclosure of true and complete correct facts. If material facts, my lord will kindly see the word, if material facts are suppressed or distorted, the very function of writ court and exercise would become impossible. Petitioner must disclose all facts having a bearing on the relief sought for without any qualification. This is because court knows laws but not facts. Now let us see my writ petition. Let us. No, it's okay. 39. You want to read, I will read. But 30 has got relevance. I'll read 39. Please, I'll connect what is why 38, whether there is material disclosed, that suppression of material fact, then we'll go to 39. The consequence of 38 will follow 39. If I can show that there is no suppression of material fact, 39 becomes irrelevant. I'll show it. Kindly look into my writ petition. Kindly look into my writ petition. Don't worry, I'll read 39. You don't have to tell what I have to read. It is my pleasure. I will. You tell whatever you want to say. Yes. 31. Kindly see para 20. See para 20, my lord, of my writ petition at page 30. Please turn to page 31 from top 1, 2, 3, 4, 5, 6, 7, 8 line. Now see 8 line. Now pursuant to the opening of the financial bid in respect of the NIT dated 6/6/24, it has come to the knowledge of the petitioner that notice of award has been issued to the respondent number 5 on 14/1/2015, but no work order or contract has been signed with respondent number 5. Is this a suppression of material fact? 14/1/2025. What is false? What my learned friend is saying false statement. This is a fact which you have said. 14/1/2000. Is my contract has been signed? Contract has been signed. It has not been signed. Is this suppression of material fact? Then what I said, in respect, so it has come to the knowledge of petitioner, notice of award has been issued to respondent number 5 on 14/1/2015, but no work order or contract has been signed with the respondent. Kindly read the word, my lord.
Sign.
Now, is sign has been signed with respondent number 5. I said the work order 14/1/2015. There is a work order which is in favor of response number 5. But there is no signing of that work order. Am I misleading the court? Am I suppressing material fact? My lord, lot of things we argue before the court. A judicial orders are being passed. We make hundreds, my lord, of the argument point by point. It is not necessary. For determining a prima facie case, it is up to the court. A judicial order is being passed. No.
One thing is that
No.
you had the knowledge.
That's why I'm putting it.
You had the knowledge that
15.
14
Yes.
was issued.
Yes.
You had the knowledge.
I had in all, I have written here, my lord.
You could have made a prayer.
No, kindly see. No, kindly see. No. Why, my lord? This is not with us. The copy of 14/1/2015 was not with us. If it is not with the court will say, how can I pass an order? Our
And
whole,
Another thing, in your amendment application,
yes.
there's also no space.
No, I don't. My lord, my whole, that's why I will show it, my lord. I'll show it. But there is already interim. My lord, what is about the case? My lord, I am just troubling your lordship again, my lord. Our whole case is technical, particular, the bid which was allowed in favor of response number 5 ought not to have been allowed. That's our case. Consequence to that, my lord, a NOA has been issued. Now, tomorrow, if your lordship finds that no, it could not have been allowed, what will the NOA will fall, my lord? Fall down. You kindly see the interim order which was passed. The last portion is regarding about my technical bid. His technical bid on response number 5. That's the whole basic and challenge before the court. NOA is a consequent to that, the technical bid which was allowed. Our whole case, you could not have allowed a technical bid. How you have allowed a technical bid? Consequent to that, an NOA. Suppose on merit your lordship decide that technical bid should not have been allowed. Then what falls? NOA goes. That's the whole facts of the whole issue here. Now kindly see at prayer portion 41. See my prayer 41. See my interim prayer. Kindly see at 41. See, direct the respondent to not to allow them to proceed with the work. Lordship got it? Now see, turn to this. Direct the respondent to not to enter into a contract with so and so. Direct the respondent authority to not allow the respondent to start mobilization of the work. Where is that separation of material fact? Where is the misleading?
There's another one issue.
No, 39.
Ahmedabad and the other units of Assam.
Oh, that is absolutely no
One
problem.
thing.
Yes.
The respondent number 5 bidded for 10 units.
Yes.
You bidded for 2,
Yes.
isn't it?
Yes.
Even that 10 units, which the respondent number 5 has bidded, and you have bidded for only 2.
Yes.
You're concerned only with the.
No, that's not the case. So now tomorrow, if the respondent number 10 will automatically they will go. Tomorrow, my lord, your lordship decide that technically he should have been qualified. That quoting the 10 units, that also will go. That's my whole case, my lord. Then, my lord, then what is the position? 10 it will go. Tomorrow, if your lordship's finding is that 10 units, which is he has quoted 10 units, tomorrow your lordship finds that technically he could not be allowed by the ONC. Then what happens? His 10 units also will go, my lord. That's our whole case before this court. What is the respondent number 5 reply? Respondent number 5 is sitting here, my lord. He has to give a reply to it. Our whole allegation is against respondent number 5. 10 units. How he can be qualified? That he has to give an answer to your lordship. Whether he can be qualified in this for a bid criteria. My lord will kindly look into it. Now my learned friend has said, you have never read that para 39. I'll read para 39 now. Kindly see para 39. See para 39. Lordship, I'll just read para 39. If the primary object as highlighted is kept in mind, an applicant who does not come with candid facts and clean breast cannot hold a writ of the court with soiled hands. Now, my lord will kindly see next. Suppression or concealment of material fact is not necessary. Is there any suppression of material fact? I'll just let me go one by one. Let me go according to me, not according to you, how to place it. My lord, now kindly see, it is a jugglery, manipulation, maneuvering, or misrepresentation which has no place in equitable and prerogative. Where is the jugglery and manipulation, maneuvering in my material facts in this case? It's a clear cut. If somebody doesn't understand the sentence or the word, I can't help, my lord. My lord, this is what you don't understand and making hue and cry, juggling and all those things. The material facts, my lord, has not been distorted. There is no suppression of material fact. Clear cut sentence. What more, my lord? Is there any suppression of material facts? What the Supreme Court said? This is not an advocacy if there is a suppression of material fact. Now, what is the main is that when I argued the matter, any argument is in advance before the court, an order is being passed. Sometime your lordship takes that order in the chamber and your lordship writes an order. Here it was an open court judgment, my lord. My lord, each and every particular thing we can't stand up and we can. Sometimes the courts get irritated. When I am passing the order, let me pass an order. So somebody is aggrieved by the judicial order, is open to them. That's why they have come for modification, variation of the order. Suppression of judicial, that cannot be. Like pointing a judge that he said that I should have come for modification, variation of order. I will not come for modification, variation of the order. Because if your lordship looks into it, the operative portion. Now let's complete this, my lord. If the applicant does not disclose all the material facts fairly and truly, but states them in a distorted manner and mislead the courts, the court has inherent power in order to protect itself and to prevent an abuse of its process to discharge the rule nisi and refuse to proceed further with the examination of case on merits. If this court does not reject the petition on that ground, court would be failing in its duty. In fact, such an applicant requests to be dealt with for contempt of court for abusing the process of the court. Of course, we agree to this judgment. Mala, today, if there was no statement to the effect that NOA was not issued, if there was no statement at all, then of course that is, my lord, separation of material facts. There is further statement, my lord. See at page 33, my lord. Kindly see page 33. Kindly see page 33. My lord, will kindly see para 22. After 2-8, my lord, you got it. First, the 22, first, second, third, fourth, fifth, sixth, 7, 8, 9. It is to be stated the ONC, after opening and declaring that technically qualified bidders and publishing the BOQ, has issued an NOA to the response number 5 on 14/1/2015 in respect of 10 units and decided not to proceed for remaining 10 units Assam till the outcome I am hearing. What is this, my lord? Is this a suppression of material facts? Distortion? Is a jugglery? What more, my lord? This is what we have stated here in both the two paragraphs. So my respectful submission is that this particular judgment, yes, my lord, this is, we can't, my lord, we accept the judgment, but you have to look into my perspective of this writ petition, whether there is suppression of material fact. This is number one, my lord, I am giving an answer to what my learned friend has said. So I read that particular paragraph 39 also. Now see, my lord, what my learned friend is saying, what it's instructed by my friend, that he said that opportunity was given to you for clarification. So if that opportunity is given, so why not opportunity to a private party, any tender?
So that is on merits.
So that's all I'm saying. What is the opportunity? That is the main crust of the matter. What is the opportunity that is given to me? My lord will kindly look into it, what the opportunity was given. And what is the opportunity that is given to the response number 5? Is a clarification which I made so far as the financial turnover is concerned. Because we said we are not a company. So statutory audit is not required. That's the only what we said. You have asked for clarification. What you have asked for response number 5 is, kindly see that. For one moment, your lordship, I'm just troubling. Maybe on merit, please look into it. There, IA, page 55. 55 kindly see. 55 of the IA, 666 of 2025.
Yes.
See this at to the private response number 5. 55. Bidders may have been given one opportunity to submit document as per BEC clause 2.1A-1 to establish a eligibility and experience. Meaning thereby, when the original you have submitted, you did not submit the eligibility and so far experience is concerned. That is apparent. My lord will kindly see what they have submitted. Keep this in one hand and what they submitted kindly see at page 120. In our writ petition, my lord, kindly look into it. 124. See 124. See 124. See, my lord, 124. Name of the work, operation maintenance. Number 2, brief scope of the work to supply skill and high skill manpower, operation maintenance, contract period, so and so by oil and natural gas company. So this is what you submitted on 1/8/2024. Closing date was 1/8. 8/10, they have given a chance. Absolutely, there is no problem. But what you have asked for, because you don't qualify the eligibility and experience you don't have on the original scope of the work. So, my lord, what was my case before the learned single judge while passing interim order? The basic challenge was you could not have allowed. Subsequent to that NOA. So, my humble submission before your lordship is one. My lord, my amendment, whatever consequence will be, my amendment will kindly, if they have some objection, let them file objection, I reply that. Number 2, my lord, your lordship will modify that order to the extent that they can go ahead with the Ahmedabad asset, absolutely no problem. So far the other bidders are concerned, absolutely there is no problem. But so far a private response number 5 is concerned, yes, your lordship will please hear this and that interim order should be maintained till your lordship decides the issue. Your lordship wants to hear it as fast as possible, absolutely no problem.
Mega project.
Now, my lord, what they said, they financially it will hamper the mega project. But at point of time, what the apex court had said in a latest judgment of 2024, kindly see at page 37. 2024, 10 SCC page 273. See these two paragraphs. Para 37 and 38. I'll just read that 37, 38. The submission made by learned counsel for respondent and project in question being infrastructure project. Lordship got it? Para 37. The submission made by learned counsel for the respondent that the project in question being infrastructure project and also one of the mega project, this court may not interfere more particular in view of the fact agreement has already been entered. My lord will kindly see in their case, no agreement has been entered into between respondent BCCL and the special purpose vehicle of respondent number 58 cannot be accepted. When we have found that the impugned decision of respondent BCCL were grossly arbitrary, illegal and discriminatory and violative of Article 14 of the Constitution of India as held earlier, government bodies, instrumentalities are expected to act in absolutely fair, reasonable and transparent manner, particularly in award of contract for mega project. Any element of arbitrariness or discrimination may lead to hampering of the entire project, which would not be in the public interest. In that view of the matter, the impugned decision of respondent number the BCCL dated 6/5/2024 rejecting the technical bid of the appellant and further declaring respondent number 8 as successful bidder is set aside. Any action pursuant to undertaken or agreement entered into pursuant to said decision also stands set aside. It shall be open to initiate fresh tender process for the project. And so here one step ahead, my lord. While deciding his agreement where they entered into agreement, that was set aside. So in that view of the matter, my reasonable submission before your lordship is that kindly this maintain that order, except your lordship can modify to the extent of A, B, C. And rest your lordship, if your lordship allows, then I will incorporate that. And your lordship can hear this matter. If respondent number 5 doesn't want to give any response to it, my lord, then it's okay, fine, that will cover.
Okay,
That's my humble submission before you.
so what about your amendment?
Yes.
Amendment will file a short affidavit.
Yeah,
Just see para H.
yes. Yes.
This is not clear.
A writ in the nature of such shall not be issued to
No,
set
no.
aside question.
The first para above that.
That the applicant said he seeks to amend the prior written challenge and notifications which is consequence to the decision of the ONC in finding the bid of respondent number 5 to be techno-commercial qualified. The notification award inadvertent not challenged as the same was not in possession. 14/1/2015 is consequence of the consequent order because of the techno-commercial bid which was allowed. That's what we did.
Eight, you said paragraph C.
Yes, the writ in the nature shall not be issued to set aside, whereas impugn online list of published on so and so because techno-commercial bid was allowed in order to of their financial quotation where respondent found to be L1 and or consequent notification award dated 14/1/2015. So if this goes also, consequence to that, that also goes, my lord, 14/1/2015.
You will express some objection here or
Yes,
you want to allow the prayer?
Your lordship will allow us 3 days time, my lord, we'll file an objection. Because this again contradicts, my lord. On the one hand, they are saying it is a mere consequence. That notification of award is a mere consequence. However, in paragraph 7, what is the sentence? Last sentence, the notification of award dated so and so inadvertently not challenged. Which means they are admitting that challenging it is necessary, but at the same time they are saying that challenging it is not necessary.
think that
You
is-
decide what you want to say.
He
You
should-
first decide what you want to say.
He should read the next line also, 2 lines. He doesn't read that next line.
India.
Yes, yes, you read the entire,
First-
which was not in possession.
756 of.
Yes.
Notice and notification
Yeah,
is
yeah.
the jugglery of words.
Third, Mr. Didas. Then it's start down. Then it comes there.
Which is item? Court number 1.
By this application, the applicant will debit petitioner. In the petition number 715 is praying for amendment of the prayer portion. Amendment of the prayer portion. Petition of prayer portion which is proposed as para 8 of the president. Issue of Mr. I. Chowdhury, then it's in the Mr. S. Chakrabarti appears for respondent 1, 2, 3, 4. 1 to 4.
1 to 4.
4. And Mr. US Bora, then it comes to appears for the para Mr. I. Chowdhury, then appearing for the respondent 1 to 4. Praise for 3 days time to file out. Praise allowed. 21.
Next Wednesday, 26.
That will be prolonged.
26 will be Thursday morning. My lord, it may Tuesday, my lord.
Tuesday.
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 29 again.
25.
Oh, let it be one Wednesday. Wednesday.
26
Wednesday, let it be.
26 তারিখ নওগাঁ আছে
No, more than 27.
25 তারিখ আর
তারিখে কোন একবার 2 তারিখে কোন এপ্রিল একবার 2 এপ্রিল কোন this so first is Tuesday, 1st April.
Or else it has to be from 4th.
4th,
Fourth.
no, 5th, 5th পুরো পাই।
Saturday.
First 4 weeks,
Third?
don't take 3 days.
Third,
How do I know?
4th মুরা না।
Then I'm saying praying for 1 week time. When do you want list on?
So we are just.
Third or fourth one?
Third, can it be on third?
Let it be third.
Third.
Okay. In the IA, I'll pass orders.
Yes, ma'am.
Today.
I'm
In the application for vacation, my lord.
My lord, I am deeply obliged, my lord.
Obliged.
Another item which is listed
Oh, we
on
will-
cycle number 32. That is a
1 minute.
separate I, which is 1080.
I.
With petition 1080. This is being tagged on the last occasion was listed. Now it's being tagged with this.
I can just remind, your lordship permission, I.
Yeah, if I go so.
I have challenged the IAM.
I-
Last occasion, yes, my lord. On the last occasion, there was a prayer made that the complete copy was not supplied, has now been supplied, but no replies have come yet.
Okay.
So this is also being tagged because it's relates to the same tender process.
Both these repetitions may be tagged together.
Yeah, that's no problem. There's already tagged. I think the only thing is no replies have come into this. I'm just informing the court, that's all.
In the mid, are you filing your affidavit?
Yes, yes.
We'll find.
1 week time?
Some more time.
Third, Mr. RP, come to the council. If the property, let the council apply for the.
I'm led by senior counsel.
Okay, Mr. I Chaudhary, let us take council. This is when it is the property. Then the council applying for the ONGC.
Yes.
Praise for weeks time to file. council.
Here, my lord, in the main writ petition, we have
It
to
is the
file.
main writ
We'll
petition.
need some time.
It will need some more time.
In the main writ petition to file a reply, because it is quite bulky. Here, your lordship will give us,
But now it's listed, then we'll come up on court again.
here we'll need at least 2 weeks time. my lord.
Then shall we detach it? Or
No, otherwise the issue is connected.
Our issues are connected.
We'll try, in that case, my lord, we'll make an
Let
attempt.
it
to
be
file.
on fourth only, we'll make an attempt.
We'll make an attempt.
Fourth.
It's item 32, WPC 1080 2023. Any private respondent? You are filing your affidavit or not? Notice to serve on the
Yes.
applicant, all the private respondents?
Yes.
There's only one private.
There's only one.
No, no, there are some, I think they have made the IM
The IAM,
service
yes.
is not complete, I think.
5 to 8.
I think service is not complete on the other respondents. These are members of the
IAM.
IEM. There is a external monitor, my lord.
Can I serve it through them if you're just giving permission?
No, no, no. We have nothing to do. It's an independent body.
We'll serve it then.
Okay, just. Let's see on what happens on four.
Yes. Great.
Obliged.
One of daily admission, part of.
Please, your lordship. Lordship, my senior is arguing a matter, part matter in lordship. Kindly, the matter may be fixed at 2 o'clock.
At 2.
At 2, your lordship.
Okay, how about the other parties?
Elementary education has already replied, your lordship. Only the health department is supposed to give replies, your lordship.
They have,
They have filed their affidavits.
Occasion, they wanted to file an affidavit.
They have filed, your lordship.
Okay,
On the last occasion, they have filed.
you file, you reply to.
No, we are not going to file any reply.
You're
your
not-
lordship.
Okay. 2 o'clock. We inform the other side.
Yes, your lordship. Oblige, your lordship.
2, 3, and 4.
May I please, your lordship? Okay, PWD is the respondent.
First PWD, Gogoi.
Gogo, yes. The matters are all on the same line, your lordship.
Anybody, PWD?
I can start if,
No point. Okay, you send someone to Ketchel of Gogoi.
Yes.
Yes. After some time.
Six.
May I please, Your Lordship? Lordship, my senior Mr. Kane Chaudhary is in Lakes in some other court. My lord, kindly pass over the matter for the time being, my lord. 6 and 7 are same, my lord. Oblige, my lord.
8.
My lord, this petition file, my lord, against the order of cancellation of my fair price shop license, my lord. Now, lordship, in this case, my lord, there are two petitioners, my lord. Now,
Yes, my lord, the court was called for, my lord. But we have not received record, my lord. Can it be around 1 week time, my lord? 1 week
been
time.
doing
Otherwise,
last
my lord,
1 year, my
cancellation-
lord.
Cancellation of license, my lord. Against the cancellation, he may prefer appeal.
No, my lord, we have given a liberty by the order of this honorable court to approach this court against this cancellation order. And otherwise also, my lord.
You go to the court. On request made by the FPT, let it go. This the matter again. This 18
18 years.
My lord, last chance may be given, otherwise
Last
matter may be decided on merit.
to enable him.
Oblige, my lord.
9.
Lordship, I think petitioner counsel was here on.
We are appealing for the industry.
I'm appearing for Lordship, respondent net fee Lordship, and my colleague, he will be appearing for the industry Lordship. Just Lordship, then pass over, I think he was here only, petitioner counsel.
Ten, 11, and 12.
Lordship, senior counsel, DCK is on his legs, lordship, for a time being, lordship.
Your Lordship, my senior is on the way. She's coming. 1 minute.
Who is your senior?
Miss M. Hazarika. Your Lordship, we had filed affidavit on the last occasion.
She will just pass over the matter for the time being. Senior counsel DCK is on his legs. Oblige, my lord.
14.
In this matter, we have filed affidavit, my lord. Proposal has been sent, but we are waiting for the vehicle bill. Vehicle bill.
No.
Vehicle bill,
No, no vehicle bill, Your Honor.
No, supply. Supply.
Supply and constructions, Your Honor.
Supply, repairing and construction. So you're filing your affidavit or what are you?
We have filed, man.
When did you file? Let's file.
I received the copy, Your Honor.
When did you receive? March.
You know, on
11th
12/3/2025, Your Honor. 12th of March.
12th March. It's not on record. Oh my. Then next week, we come and. Third, Mr.
VN Upadhyay, Your Honor.
V. Nobadia, Learned Counsel Petitioner, Mr. G. Pakalio, Learned Government, submit that they file affidavit on 12/3. 12/3/2025. Top 1 week.
Yes. Hello, Blanche.
15 to 22.
Mr. Saitya is on his legs,
Yes.
so we'll take up after some time.
Where's the name? Oh, seriously. Come on, 18.
Lordship, in all these matters, Lordship, 11 or 72 lakhs 20,000 has been allocated, Lordship, to mitigate the liabilities in the next financial year 2020, 25-26, Lordship. And department will proceed accordingly in the next financial year, and it will be started from April, 1st April.
When can you pay? Now you have got, how much is your total amount? All the street kitchen?
Total amount is,
All these are agri department, isn't it?
yes, same department, same tender.
We have only two matters, no?
No, we have 13 matters.
You have
13 matters.
13 matters.
13.
So around, all these around 5-6 crores.
5-6 crores. So it will cover 5 years.
Lordship.
There will be some
But
budget.
it cannot be a common order. Cannot be a common order.
I think
It's-
it can be only admitted amounts are yet to be paid.
No, but that's
But-
fine.
But different, since there is different repetition, different orders can be,
Same order can be passed in all the writ petitions.
only
If
the
your
facts and
lordship-
figures should be different.
Different.
Facts and figures should be different.
Can you do it?
I will provide all the facts and figures.
We can give a chart against the case number and the amount. So your lordship may have it, any day your lordship, he will prepare that and give a copy to her, and then you can, your lordship pass one order and the same can
Same.
cover.
Correct.
And,
Okay, then you make a chart
that will be better.
against each writ petition.
Ah.
All the facts, all this. Then we'll dispose it all.
Yes.
Since now that 1,172 lakhs is allocated to the agriculture department
Okay.
for the financial year 2025-26 under SOPT-G, I don't know what is this, against pending liability.
So that will cover our liability.
That's why I was asking you.
Yes.
How much is the total?
That amount also,
It comes
he will
in
mention the amount
Ah.
against the case number, my lord, and also
Okay.
the total amount.
We can
that
do
you have
that.
told.
Let's bring a chart. When can you submit it? Can you
Yes, lordship may fix any date.
give your continued date?
This next Monday.
Next Monday,
Chart is the previous cycle.
আজি Tuesday है, Friday আহিলে হে।
Friday.
Friday আহিলে
Friday,
হে।
Friday আহিলে.
Your lordship can have it on Friday, my lord. It's just
Friday.
one page.
Friday.
Mr. A. Chalia. This the matter of 20%.
This Friday. Deeply obliged.
And keeping this,
Lordship, I will, I will,
you have only one copy.
Lord.
Give a
I'll
photocopy.
give a copy.
Publish.
30 of supplementary list admission.
Lordship, in item number 30, Lordship, the amount that the petitioner is claiming that has already been paid, Lordship. On 7th of, as per records on 7th of March itself, the amount has been paid. Should they file this petition for payment of works related to, which was a work allotted by this Directorate of Border Protection and Development, Lordship. So there was a pending amount. As per our records, the amount has already been paid, Lordship.
But my lord, yes, my lord, but interest has not been paid, my lord.
Interest?
Interest. May I pay?
Interest part is, the interest part, Lordship, we had received, Finance Department had received a proposal worth 24 lakh, which was admitted by the respondent parties. that after deduction of the TDS, that amount has been paid, Lordship. Regarding the interest part, Lordship, we are not aware of.
Are you pressing for the interest?
Yes, Lord.
When was the work order?
Actually, Lordship, may I pray, Lordship, Your Lordship, may kindly fix this matter on the next week, Lordship. Actually, today we have some difficulties, my Lord. My senior, she is on leave, Lordship. Next week.
Regarding my lord, interest per my lord, they may have to oppose the civil court, my lord, it may be disputed among my lord.
Yes.
Next week.
On request, you have MS?
Be here.
It's after 1 week.
Had filed a case stating that there was discrepancy in the EMD amount in the tender papers. Based on that, there is a stay order authority. We have filed our affidavit, and I think they will file their reply. My only request for lordship is, since it's a tender matter and it's a construction related matter, there's a stay order. It will be fixed on a particular date for disposal. It's a very small issue regarding that they are
You
saying.
file your affidavit today?
It's been filed. I think it's on record also. Your Lordship.
Yesterday, we have received it, my Lord. The affidavit. We'll file a reply to the affidavit.
Another issue, Lordship. Respondent number 7, they had filed this case at a stage where they say that they didn't know as to whom the work order will be issued. So they made 2 of the technically qualified respondents, bidders as parties. Now the work order has been long back issued. I have annexed that in my affidavit also. So therefore, respondent number 7, who was one of the technically qualified bidder, is not a necessary party herein. And for notice for him, it is awaited. And he is not a necessary party. That name will be struck off. I think he will agree to that.
My Lord.
Well, you'll have to make an application. Now we cannot just strike it off. There's a notification to that effect.
He's not a necessary, yes, that is true. But he's not a necessary party.
I'll file it on the next day.
In the meantime, are you filing your reply?
No, we have received yesterday, my Lord.
Oh.
We'll file a reply, my Lord.
Okay.
2 weeks time may be given. 2 weeks time may be given to file a reply, my Lord.
2 weeks time.
My Lord. There, what is the new facts? No, we have to ascertain.
It's a residential school construction activity, which is now there's a stay order.
Date may be
When was
fixed.
the stay order passed?
On 11/2, Lordship. And the work order was issued on 31. That is also not another challenge. On 30th of January, the work order was issued. And the petitioner filed this case saying that they don't know whether work order is issued or not, and there's a stay order.
But the work order was not uploaded in the portal, man. That's our instruction.
So
we'll file our reply, man. The detail is
this writ petition may not also suffice his cause because the work order, which is the actual document, is not under challenge in this proceeding.
But the work order was not uploaded in the portal, man. That's what we have stated.
This petition would survive in this
Reply,
fashion, I
man.
do not know.
Your Lordship may decide the matter. We'll file a reply to the reply.
Okay, Mr.
M. Smith.
Learned counsel for the petitioner. Praise for how much time?
2 weeks time, man.
I would object to that 10 days time.
Similar to 4 days more, man. I'll file within the
Praise
before.
for 2 weeks time to file reply to the counter filed by the
Respondent number 3
3 to 6.
to 6.
Mr. Bidas, Learned Counsel, enters appearance on behalf of respondent number 8.
They have received the work order.
Are you filing your affidavit? And also praise for 2 weeks time to file counter affidavit. Praise a lot. List on 2 weeks is what?
2nd.
2nd April?
2nd April. Yes, Lordship.
Yes.
Or can it be on 1st of April, Lordship? It's a hearing day.
Okay.
1st of April.
1st April?
For admission hearing, Lordship.
All of the interim may be continued.
Interim order passed.
Till then.
Till the next.
Till then, Lord.
Yeah.
Oblige, Lord.
24 to 27 hearing.
No, not to the law. No, sir.
Maybe. Is a part of matter, not it?
Who is Ben Sharma? Elementary.
Education department is PN Sharma.
Yes.
PN Sharma.
Okay,
Or
we'll
if
take,
you can-
take up after some time,
Yes,
let him
yes.
come.
Twenty-eight.
Me, please, your lordship. My senior is not feeling well, so this matter will be taken up next week.
There was an adjournment request. I think.
Yes, yes.
Yes.
Okay,
Only,
request-
only difficulty will be next week, Lordship. Can it be after the Bihu holidays, Lordship?
On request made on behalf of Mr. A. Das Gupta, London Senior Counsel for the petition. Resound, give a date after Bihu.
18th. 24th of April?
Yes. Yeah.
24th of April. Oblige, Your Lordship.
33 of supplementary leave.
My lord, the other side is not certain.
Who was there on the other side the other day?
Yeah.
Respondent one wanted to file an affidavit, isn't it?
Yes,
Has it come?
no affidavit. According to my information, he has not filed anything.
Who's the respondent on counsel?
Let it be last part of this month, my lord. 27.
Heard Mr. O.P. Batil and the counsel for the petitioner. None appears for the respondents. Place the matter again on. We'll have it on 25th.
Let it. Much.
9 of daily list.
May please, your lordship. I'm grateful that your lordship has passed over the time. My lord, this case is relating to my lord grant of subsidy, my lord, food subsidy. And my lord, the Ministry of Food Processing, my lord, they have issued a, my lord, notification at page 32, my lord. Page 32, that is the scheme. Government of India Ministry of Food Processing Industries, which is valid from 13 to 17. Page 30 is the main page. Thereafter, my lord, the conditions are at page 32. Page 32, objective I'm reading. Scheme as page 30, my lord. 30 page, and my lord, relevant paragraph at my lord, page 32. The guideline for implementation of scheme of technology upgradation, establishment, modernization of food processing industries during the remainder of 12 plan 2013 to 2017 under NFEP. Para 1, objective. The main objective of the scheme is to increase the level of processing, reduction of wastage, value addition, enhance the income of farmers, as well as increase exports, thereby resulting in overall development of food processing sector. The scheme envisages to extend the financial assistance for establishment of new food processing units, as well as technology upgradation and expansion of existing units in the country. Here, my lord, my petitioner is, they are already having it, and this is the expansion unit they have set up on my
What
lord.
do you have? What? Yes.
Page 32, my lord. First paragraph.
You are engaged in manufacturing what?
Manufacturing of bread, biscuit, cakes,
Okay.
etc. It's a bakery unit, and it was set up earlier. So after this my lord scheme, they have applied for expansion of existing units. Expansion unit, my lord. Placing my lord new machineries installing new machinery, and modernization of the plant and machinery. The eligible sectors, food processing sectors like fruit and vegetable, milk, meat, poultry, high products, fish products, cereal, other consumer food products, rice, flour, pulse, oil milling, and such other agri-horti sectors, including food flavors, colors, condensed spices, coconut, mushrooms, wines, soap, will be covered under the scheme. The activities of aerated water, packaged drinking water, and soft drinks will not be considered for financial assistance under the scheme. Since they are using floors, my lord, so they are included, they are eligible in it. Then eligible organization, all implementing agencies, organizations such as government, PCOs, joint ventures, NGOs, cooperative, private sector, individuals engaged in establishment, upgradation, modernization of food processing unit would be eligible for financial assistance under the scheme. Pattern of assistance. The scheme envisages financial assistance to food processing units in the form of grant in aid, 25% of the cost of plant and machinery and technical civil works, subject to maximum of rupees 50 lakhs is in general areas, and 30.33 of the cost of plant and machinery and technical civil works, subject to maximum rupees 75 lakh in different areas, so and so, including Malad, Assam, and integrated tribal development project, so and so. 50% per annum machinery, so and so. So,
There's
my
no
lord,
Assam here.
Assam is not here, madam. Jammu and Kashmir, upgraded Andaman Nicobar Region, and integrated tribal development project, TDFP. Then, my lord, 50%, we are getting 50%. Next, 50% of the cost of plant and machinery and technical civil works, subject to maximum of rupees 1 crore, 100 lakh for northeastern states, including Sikkim. So we are getting more. Come on, that is. So we are getting more, my lord. The northeastern states, they are getting 50%. Here is a list of ineligible components. It is not up to. The main catch is that the petitioner has applied in 2014.
Where's your application?
Dispute is there, my lord. Application is, my lord, at page 35, Annex 30, page 35. Application for grant of financial assistance and under technology upgradation, establishment, modernization, expansion, so and so, so on. So petitioner has applied by submitting this application, my lord. Page 35. It was received on 26 March 2014.
Where is the date? Okay.
Page 35 minutes, Annex 30. 26 March 2014, they have submitted this application. Thereafter, my lord, give me all details, my lord, up to page 38. Thereafter, my lord, the inquiry report was prepared after going through the detail of inquiry, page 39. Inquiry report for grant of under upgradation, establishment, modernization, food tank. It was forwarded, my lord. This is the inquiry report. Thereafter, your lordship, please come to page 42, my lord. Page 42. Comments of the inquiry officer. Page 42, in the middle, my lord. Comments of the inquiry officer. Certified that I have examined each and every particular furnished by the claimant, Mrs. Bivavaka, a unit of Bivavaka, and so and so, and annexed relevant documents furnished with this claim and found them to be correct and beyond all reasonable doubt. I have also personally visited the unit on so and so, and the prices mentioned in the application of land, building, plant and machinery component items and original components, and found them to be correct. So this is the report he has filed, my lord. Thereafter, my lord,
So your phone entitled to 57 lakhs?
Yes, my lord. We are entitled to 57 lakhs, 24,000. Thereafter, my lord, after the report filed by the functional manager, my lord, page 43, next page, The general manager forwarded my claim, my lord. Subject forwarding the application of financial assistance, so and so, so and so. With reference to the caption subject, I have the honor to forward herewith the application for availing financial assistance under so and so, duly filed and signed together with required enclosures as received from so and so, located at so and so, district so and so. This is an existing unit and now envisages an expansion cum moderation program. The unit has submitted all the required documents as per guideline of NMFPF. The project is under implementation with the financial support of Punjab National Bank, Kilshore branch. The claim has duly been verified by the functional manager C so and so. An inquiry report, the prescribed format is also enclosed here for favor of your kind consideration. This was forwarded. Thereafter, my lord, CA report is also there, next page, 44. Bank letter is also there. They have obtained bank loan. Thereafter, what happened, my lord? The file was lying there in the office of the, my lord, Commissioner Industries, but that was never put up before the SLC. They have forgotten or it was misplaced, whatever. No communication was given to the petitioner. So they were asking, my lord, it will be put up, it will be put up. Ultimately, they have approached this court, my lord, in 2017 by filing page 48, my lord, by filing a WPC, alleging that, my lord, their file was never placed before the SLC for consideration or approval of the amount. The Honorable Court passed an order, my lord, giving details here. Just reading the few last paragraphs, my lord. Page 54.
Yes.
It's page 54, 11 paragraph I'm comparing. Paragraph 13 I'm reading, my lord. Since the petitioner is aggrieved by non-consideration of its application for granting it by the appropriate committee, that is the state level committee, notwithstanding the fact that this scheme has since been withdrawn, this court is of the opinion that the matter requires proper inquiry at the hands of the concerned departmental authority, who must consider as to what relief, if any, can be granted to the petitioner under the law. Even at this point of time, it is found that the application submitted by the writ petitioner complete in all respect was received during the currency of the scheme.
If it is, if she
If
has
it is
resolved.
not, no, it is not. If it is not there in the that the application submitted by the writ petitioner complete in all respect was received during the currency of the scheme. Then, my lord, paragraph 14, for the reasons noted herein above, I am of the view that the application submitted by the writ petitioner seeking financial assistance deserves to be considered on merit by the appropriate authority. As such, this writ petition is being disposed of by providing that within 4 weeks from today, the writ petitioner may submit a detailed representation enclosing a certified copy of this order before the Additional Chief Secretary to the Government of Assam in charge of Industries and Commerce Department, ventilating its grievances in the matter. If such a representation is filed within the prescribed period, the same may be considered on. So is disposed of by the in the light of the observation made herein above, as well as in the decision rendered in vision spot so and so within a further period of 6 months. It is made clear that if an examination of the representation submitted by the petitioner, the departmental authorities are of the view that the application submitted by the writ petitioner was a genuine one and the same was complete in all respect and was also submitted within the period of validity of the scheme in question. In the event appropriate steps may be taken for redressal of grievances of the petitioner, as may be the permissible under the law, whatever be the decision, the same may be intimated to the petitioner through a written communication. So here, my lord, it was the direction was given to the, my lord, additional chief secretary. This order before the additional chief secretary to the government of Assam in charge of, my lord, industry, commerce, etc. But, my lord, a speaking order was passed. Accordingly, my lord, page 56, after the judgment of this honorable court, the petitioner filed a detailed reply, my lord, detailed representation before the, my lord, additional chief secretary, page 56, my lord, giving all details, cases, etc., my lord, representation. But nothing was passed by the additional chief secretary, but the commissioner passed a very lengthy order. Commissioner of Industrial Commerce, that is on, my lord, page 65. It's a very long order. He has neither, my lord, reputed nor accepted, my lord, some kind of order he has passed. Thereby, my lord, the impugn order, my lord. It's a very long order. Whereas the represent page 65, whereas the representation dated so-and-so addressed to the additional chief secretary, government of Assam in charge of industry, so-and-so, so-and-so, submitted by the director of so-and-so, so-and-so, received on 26 August 22 and perused. Whereas Vibhavaga applied for applying so-and-so, all these are facts, my lord. The applicant had applied for so-and-so, 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 whereas during scrutiny of the documents submitted along with the proposal of Messrs. Vibhavakars in the office of mission director so-and-so, following observation were made. The industrial unit under reference is an existing one. Expansion for the same reason, a thorough scrutiny of the documents of the machineries existed thereon prior to expansion on machineries proposed or after expansion was required to be done by way of both field verification and cross-checking of documents will bill vouchers. There was also requirement of verifying the payment documents of in the machineries of other so-and-so proposal which was purchased for bank, related bank check, numbers, demand draft numbers, certificates, proof of making payment through bank along with bank statements. As per clause number so-and-so, the scheme guideline and affidavit duly executed on the residence of so-and-so. Whether the organization seeks the consent so-and-so, then whereas the unit had informed by an affidavit dated so-and-so that an amount of rupees so-and-so, a financial assistance for setting up this unit in the past was received from Ministry of Food Processing by sanction letter so-and-so, 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 2012. For this further requirement of verification of documents were needed to ascertain the admissible amount of so-and-so and graduation so-and-so. So many things are written, my lord. Main cuts of the matter, my lord. Written argument, written argument.
Okay.
There, my lord, so many things are written. What happened, my lord? Since the, my lord, filing of the application, till, my lord, filing of the earlier WPC, no communication was made to the petitioner, either you submit this document, that document, nothing. File was gathering dust. It was not placed before the appropriate authority also. And, my lord, no communication was made, as my lord made in our different cases, my lord. If any sort of documents is there, they should have, my lord, asked to submit the documents, but no communication, not a single communication was made, but the file was gathering dust. Thereafter, my lord, after the judgment, it was directed to the additional chief secretary in charge of industries, but my lord, the commissioner has passed the order. He is, my lord, Commissioner of Industry and Commerce, Duke Bhavan. The matter was probably never placed before the additional chief secretary, my lord, who was found to be responsible. In the earlier case, my lord, they have filed an affidavit of opposition. Twice also they filed. In the page 73, they are affidavit of opposition in the earlier case, my lord. Page 73. Paragraph 2, page 73. That answering respondent on receipt the so has understood the content of having understood on the answering so. Yes, it was a plain, my lord. Lordship, you can see page 74. 74, para 7. That with regard to the statements made in paragraph 7 of the writ petition, it is stated that the Ministry of Food Processing Industries, Government of India has discontinued the implementation of National Mission on Food Processing Scheme during the 12th plan also with effect from 1 April 2015. But it was filed in March 2014. In view of the aforesaid discontinuance of the aforesaid scheme, the claim of the petitioner could not be entertained. Thereafter, again, it was reinstalled, no? Again, it was continued, my lord. At that time, my lord, the scheme was stalled, discontinued. Thereafter, again in 2017, my lord, they have again continued the scheme for a few months.
Scheme was not completed.
My lord, the court has held that, my lord, during the validity of the scheme, they have applied and nothing was, my lord, processed. That's why, my lord, he became aggrieved.
According to the order,
Yes.
there were a lot of deficient documents in your application, and they have informed you over the phone.
They are the, my lord, the
But
notable
there
agency.
was no response, and you submitted only on 16/4/2015. That was after the scheme has been discontinued or
discontinued.
lapsed, whatever you call it. So what can we do now?
But during the validity, my lord,
During the validity of the
no communication was made to, my lord, to submit any documents. That is the case, my lord. And, my lord, the nodal agency, my lord, that GM and the functional manager, they are the appropriate authority for scrutiny of the documents. So they have scrutinized all the documents and forwarded to the office of the commissioner. Then office of the commissioner should have within 1 month, 2 months or 3 months, whatever it is, my lord, they should have, if any sort is there. That is after filing of this writ petition, they have made this afterthought allegation. Because during the earlier period, before the filing of the writ petition, no communication was made asking for any documents. Thereafter, my lord.
See, come.
They have filed several affidavits.
Page 66.
Page
66.
66. Yes, my lord.
Yeah, just read that.
In the speaking order, yes, my lord. Whether the organization, sister concern, related companies, group companies, as well as the company itself, avail any financial assistance. There's no doubt about it. Earlier, my lord, they have received in 2012 one kind of, my lord, subsidy for the first installation. Second, my lord, that the organization has not obtained, applied, or will gain subsidy from any minister, so and so, so that affidavit was also given, my lord. Affidavit was submitted because all these are, my lord, as per the checklist. Whatever document is there, as per the checklist, they have submitted. That's why their proposal, GM is a responsible officer, my lord. He has forwarded to the commissioner because as per the checklist, all documents has to be there. Otherwise, they will never, my lord, forward the case of the petitioner. As per the checklist, he has submitted everything.
Yes.
Then, whereas the unit had informed an affidavit dated so and so that an amount of rupees 7 lakh and some setting of this unit in past was received from Ministry of Food Processing by so and so, so and so, so and so. For this further requirement of verification of documents were needed to ascertain the admissible amount of so and so, so and so, so, including the amount already received. That is not a hiding fact because they have only given, my lord. For them only, not for different authorities. Yes. Whereas though the proposal was submitted within the validity of the scheme. Yes, my lord, the application was not complete in all respect. The following documents were not submitted along with their application, which was informed to the unit on several occasions via telephonic calls. That is absolutely, my lord, false. If the call list is, my lord, checked, then, my lord, they have never received because everybody is interested in getting, if they file the application, everybody is interested to get the benefit. So, my lord, this is a false plea, my lord, given and entirely.
Keep on reading.
Yes. Duly unauthorized so whereas the proposal was so the removal cost. Duly unauthorized COT bond executed beneficial so as per chartered account certificate, that is also I have enclosed here. Whereas during the process of verification, it was found that the following documents were submitted by the petitioner along with a forwarding letter without mentioning any date. The documents submitted were as follows: the CUT bond without so and so signing, same was authorized and signed on 16/4/2015. A certificate dated so and so from chartered accounts certifying the investment made by the petitioner for expansion cum modernization. A list of unsecured loans dated so and so, certificate of accounts so and so, chartered accounts of the petitioner. A certificate without any date issued by the Punjab National so and so 15 lakhs so and so. Whereas it is clear from the above mentioned documents that though the petitioner had submitted the application for grant in aid under so and so on so many required documents were submitted by late so and so. Therefore, though the authorities processed the application of the petitioner, the same could not be placed before competent committee for consideration. By that time, the Ministry of Food Processing Industries, Government of India, dealing the scheme from union budget with effect from so and violation on so and so. Where Ministry of Food Processing Industry so and so had clarified that no Government of India funds would be available for implementation of NMPP states from financial year so and so.
So the issue is,
Late filing.
they've informed you
Lately.
to submit these documents.
Yes, ma'am. But
Now,
my lord,
if you did not get the phone call or whatever information, how would you have submitted this on 16/4/2015? Obviously, you were informed.
but they could not press any document or any letter whereby they have informed me, my lord.
But then this
This is written, my lord, and my lord, another
your
thing.
submission of the documents
The
on
documents are here.
16/4/2015. Where is the
Documents are,
chartered account and the
they have
document
enclosed.
which you showed me earlier?
Chartered account I have placed, my lord, that is dated. This petition also it is there. Chartered account. Chartered account is, my lord, 29/3/2014. No, sorry. Date is, my lord. Chartered account is dated, my lord, 25/3/2014 for my lord. Page 44. Chartered account certificate is at page 44. That is dated 25/3/2014. Left side date is there, my lord.
Then what is this?
Number one.
Page 66. 16/4/2015, 16/4/2015.
Thereafter, my lord, the bank certificate is also there.
In fact,
Bank certificate also, my lord,
we
25.
have filed an affidavit. In the affidavit, we have given those documents.
Documents,
which have been
that's,
submitted.
I'm placing it, yes. In the affidavit, they have enclosed the, my lord, documents. Please give me a minute.
It starts from page 84.
84. Double dash, 84 is the document they have submitted, my lord. Number one,
starts from
page 95, 95, my lord. page 95, that is the affidavit. Applicant company HR has obtained rupees so as financial assistance for setting up this unit, so verification. It is dated March 2014, my lord. 21 March 2014, affidavit, which was submitted because as per the checklist, it's submitted. Son Director Grant, so and so, dated 29/3/2014, page 9. What are they have submitted with reference to the above, we are page 96, your lordship may kindly see, with reference to the above, we are submitting the following for release of grant under so and so. That is State Mission Director. Surety bond, affidavit, certified that we have utilized so and so, term loan so and so, so and so. CS certificate and actual expenditure. I hereby undertake to display signboard as the project is assisted under the centrally sponsored scheme National Mission on Food Processing. That is not there, of course, in that. Thereafter, the surety bond. Surety bond, my lord, was submitted. That is so without any date. My lord.
It was notarized on 16th.
Notarized. Chartered account, another chartered account document. 4 of 2015 and 4 of 2015. Affidavit reply and 3 paragraph from the affidavit reply, my lord. Paragraph 4 of 110. Yes, not side of the closure of the scheme. That paragraph 4, 110, my lord. 110. From the reply, I am reading, my lord, that as regards to the statements 110, paragraph 4, that as regards to the statements made in paragraph 3 of the affidavit position, answer application was filed on 26/3/2014 before the Ministry of Food Processing Industries praying for financial aid. Thereafter, inquiry was made and after thorough scrutiny and physical verification of the project, the GM DICC Kasar Silsar by letters and so forwarded a proposal of the State Mission Director. The respondent for hence, it is evident that the application was filed very much within time. The proposal was also duly forwarded by the so and so. Kasar much ahead of the closure of the scheme. As such, due to no fault of the petitioner, the respondent cannot take a stand that the claim of the petitioner could not be entertained, which is not a valid reason. Thereafter, my that the fact that the petitioner has received a subsidy of for establishment of original unit so and so, applied for the grant in for expansion of the unit as the scheme has specifically stated in its guideline regarding eligibility criteria for receiving grant in aid for upgradation of so and so, so and so, so and so, so and so, same unit. Therefore, it is not irregular or illegal to apply for grant in aid for the above mentioned scheme for installing a separate machineries for modernization of the plant and machinery, and nor there is any bar or receiving of grant in aid under the above mentioned scheme. But the responsibility by repeating the same allegation of receiving second grant in aid is trying to mislead the honorable. I will go back some. So my lord, for the expansion unit, they are entitled. Originally, unit was established, no doubt, they have got some.
No, what do you say about these documents in your reply?
Documents, my lord. Documents, my lord, they have filed. Because why they are sitting, my lord, till, my lord, April next year? Already on 1st of April, this scheme is closed. It wasn't from March, my lord, March 2014. There is a gap between,
According to them,
yes.
you submitted your documents on
My lord, on, yes,
signed
my
on
lord.
16th.
By that
2016.
time, the scheme is closed.
Yes. And
By
in
that
the
time-
earlier affidavit, in the earlier writ petition which they have filed,
Yes,
they've taken those grounds, isn't it, in that affidavit?
yes.
So what do you say about these documents which they have enclosed in the affidavit in opposition?
That's my lord, no communication was made because they have filed within time on 2014. They should have, my lord, asked.
Communication
before a
was made,
certain
that's
date.
why only you filed the document.
Others also, my lord, my lord, if
Unless
any
you have the
short documents, because after 1 year, they have communicated me after 1 year to file the documents. And earlier documents, my stand is, my lord, I have filed the documents. These are above earlier. Thereafter, my lord, they have again, my lord, when they are inquiring, my lord, your lordship is not satisfied. My lord, when they have again inquired, I filed by the time the scheme is closed. By that time, scheme is closed. But my lord, the cases, not only my cases, other cases which was filed within the time, that was, my lord, that was processed, and my lord, that was, my lord, subsidy was given. You cannot deny it. The proposals, whichever was filed within the time, their cases are not cancelled. They have paid their, my lord, after consideration of the, my lord, particular cases, they have released the subsidy amount. Those cases in which, my lord, the filed within time. My cases was filed within time. It was under process.
You filed within time.
Yes, my.
But there was shortage of certain documents.
Shortage of certain documents.
Which they asked from you and you submitted on 16 for.
Whatever documents are there, my lord, when they have asked us, you please file these documents, then they will file. Accordingly, when they have asked for other documents, they have filed. So earlier also, their stand is that they have because
When did you ask for the documents?
Lordship, there was a continuous communication with the parties. Usually what.
Was it written or?
No, it was, I have been told that they have, because their party, the general manager usually makes the communication. So general manager stays in station only, this unit is from Silchar. The party is there. They call over the phone and come and like give the documents. So whatever, Lordship, whatever may be the cause, whether it's a like telephonic call or written communication, they were aware that certain shortfalls were there. And accordingly, they have submitted those documents much after the scheme is already been taken away by the central government. So in that circumstances, also what a department can do. So our stand is very simple and clear, Lordship, that Lordship, an application which is not complete is not at all an application. Application has to be complete. Then only it will be termed as an application. So their application was not complete. And they have submitted these documents, Lordship, you can see, without any dates. They have given a forwarding letter without any dates. They have given this security bond without any dates. We could find out the dates only from the notarized date. So that's how they have, like very casually they have given these documents. And by the time, Lordship, that central government has taken away the scheme, state government cannot do anything because it was 90% and 10%, 90:10 ratio of funding. State government has also discontinued it. Now, Lordship, there was no liability as such has been caused. And filing an applications, there is no right if it is not complete and it's not as per the guidelines.
Yes. GM is the, my lord, appropriate authority for scrutiny of the documents and, my lord, forwarding. He is the responsible officer. He is the head of the district. So he, after verifying all documents, he has forwarded their case. Afterwards, my lord, he should not have. This is the second time again because they have misplaced. In other cases
Has
also.
the GM filed an affidavit?
No, Lordship, we have a GM, let me check. Lordship.
Is the GM party here?
The
Yes,
GM is a party, but
GM is a
like a
party.
GM, a lot.
GM has not filed, the officer of the commissioner.
We in the industries department also, there is an authorized officer who files for the department. So he is a responsible officer. I'll just check who has filed it. He is the general manager, he is the general manager only. Page 90, Lord.
Deputy general manager,
Page 90,
92.
Ritumani Pasani.
Deputy general manager. He is in Assam Industrial Infrastructure Development Corporation.
Yes,
Apana,
so
there is some
mission,
other cell,
Lord, sir,
in-
mission
industrial
director, mission director, that food mission directorate was basically, it was part of AIIDC earlier. So that is why he has signed it. That mission directorate is no longer there. Let's say. So nobody is
Let
there
the-
to sign
I
it.
think why not let the GM file an affidavit, man, and why not you
Now that
submit
this
it,
is what. All the documents are there.
you don't document why he will forward, why that document why he will forward, it is your responsible officer, head of the district. The Tarun some may be misplaced and will ask for further that you file it again. That's what happens with the government offices.
No, this affidavit is filed only on the direction passed by this court
Yes.
my lord.
to produce that
So actually, what has
affidavit.
happened, let's say, we have filed two affidavits in the earlier round of writ petition. So one affidavit was annexed by the petitioner, but other affidavit, which was the most relevant affidavit wherein these documents have been submitted, that was not annexed. That is why court has passed an order that to file, directed us, they bring that affidavit on record. That is why we have filed this affidavit to bring it on record.
So that is
Let us-
starting from page 89.
Yes, page, it is start, yes, that earlier affidavit starts from page 89. Yes, correct.
So here the GM filed the affidavit.
Yes.
Let us read the functional manager report, my lord. What are the documents he has forwarded? Page 39, functional manager, inquiry officer, he has forwarded the
In
case.
the
when
GM's
recommended.
affidavit,
Officer the GM.
in
is
the GM's
functional manager.
affidavit,
Yes,
which was filed in that earlier writ petition,
yes, ma'am.
paragraph 6, you see page 92.
A list was given that the answering department was filed without mentioning any date. The documents submitted were as follows, so and so.
And they were silent
But
on
when-
their reply on this.
But my lord, what are the documents submitted, that will be reflect from the inquiry officer, my lord. Functional manager. Let us read that because it is the photocopy of his, my lord. There is affidavit is a different thing.
Where is the
filed by
functional
the-
manager's
Page
report?
39, my lord. Page 39. From the form. Date of receipt of application, so and so, center, so and so, what are documents, private limited company. That is also the media, so and so. Note, so and so. Acknowledgement of entrepreneur memorandum, so and so number is given. Acknowledgement entrepreneur memorandum, agreement of industrial entrepreneur memorandum, so and so. Factory registration, existing unit under going modernization come expansion, that is there. And proposed date production operation so and so NA, date of going into commercial production so and so, proposed October so and so. This is the checklist actually, my lord. Details of land and building unit so and so, specify whether so and so list, specify the mode of owing such by way of inheritance, gift or so and so NA.
Isn't the
Total so and
application-
so. Application, no, this is the report of the functional manager, exactly.
This
So whether he'll say, no, whether I have filed or not, it is a checklist. If held under lease, yes. Name and address of the owner, so AIDC Limited. Date of agreement of which so and so. Period of lease agreement, so 60 years. Government agency, yes. Name of agency, AIDC, date of agreement, so and so, lease agreement, so and so. That so and so, under the factory building has been constructed, if so, yes. Date of starting the completion of the civil works, so and so, expected completion June, so and so. Total area under construction, so and so, factory, so document. That an estimated cost factory has been allotted by the government agency, name of agency, and so relocation. Annual rent fixed for so and so, particular new unit, existing unit, undergoing expansion, modernization, land, site development, building, factory, so and so, association, so and so, means of finance, promoters, contribution, so and so, inquiry, term loan from financial institution, 1 crore, in unsecured loan, so internal resources, so and so.
We just can't keep on acting like this. You have to come prepared.
No, my lord. Documents were submitted.
To that affidavit in opposition, which was filed in the earlier writ petition
Sir,
by the
yeah.
general manager.
My reply
Where's
is
your
there.
reply?
My reply is there. Yes, my lord, I'm placing it. So NOC from local, everything, all documents, my lord, list is there. This is the checklist.
Where's your
As part of
reply?
checklist, apply, yes, my lord, reply I'm placing, my lord. That this is based. At page, it is my lord, reply, if you reply starts from my lord, is 103, and regarding that, my lord.
No, this is the reply in this
Reply is-
affidavit.
reply is
Reply
relevant
in this
paragraph 105.
reply in this writ petition.
Yes.
But your reply to that affidavit in opposition in that earlier writ petition,
Here I am closed.
where have you enclosed?
That is, my lord, starts from my lord 101. It starts from my lord 103. If you didn't reply by the petitioner.
They have annexed it, yours.
I'm enclosed it.
Enclosed it. Annex 108.
108.
Paragraph 4, that the petitioner further states that the managing director of AIDC, Assam has written letter on so and so, fight no and so number and so. The joint secretary of government of Assam Industries, Commerce and Public Enterprise Department, stating that the unit is eligible for availing benefits under the scheme so and so for additional so and so. As such, there is no scope or to reject the proposal of the petitioner without placing the proposal before the state level committee, government of Assam. That the
We'll continue
deponent, the deponent to state that it is not.
We'll continue at 2.
Yes.
Otherwise, if you want to take instructions and come back, I can give you some time.
Let it, my lord, at 2, my lord, your lordship.
It's very simple,
This
lordship.
is
Lordship
very
has already
simple.
got to.
My lord, that during the pendency, they have submitted the application, and if anything goes, my lord, that all cases.
As per the checklist,
As per the checklist.
the required
So if any
documents are not there in the
additional
checklist.
document
They
is
have not-
required,
lordship,
then also other cases they have processed. But this
Other
file
cases, they must have processed.
processed because in
But
the
then,
validity they have paid. Government of India has paid the,
Because the documents were, they had the documents
yes,
accompanying with the application.
no.
But
When I have
in your case,
yes,
yes, you submitted on time.
yes. The
But
further
there
documents,
were certain shortfalls of documents
yes,
which required from you,
yes.
and you submitted it,
Mm.
which were all signed on 16/4/2015
Only one
after
thing
the
is,
closure of the scheme.
only one thing, my lord, that although the scheme was closed, the application filed earlier, they have been given subsidy because it was under process. My file was say under process, though they have not that cut off that we are closing it, that is not. The application filed during the pendency, my lord, validity of the scheme, that has been allowed. They have not stopped. That is the only instruction he has to take, my lord. That during the validity of the scheme, whatever, my lord, scheme, my lord, applications are there, they were processed and they were paid. I can give the name.
Now, lordship, that speaking order makes it very clear that they have paid only
Hmm.
those
which those were processed and clarified and cleared by the SLC.
That's
The liability has been created, so those liabilities has been disposed of by the government.
Come on, I'll take in section at 2, Your Lordship, again.
Could it be taken up tomorrow, Lordship? I have the consent of the other side out.
Okay. At MSM Hazarika, then the senior counsel for the petition. And request made by this IKEA. You're not AG, no?
In this case, not.
Then the senior counsel for the respondents. Tomorrow?
Tomorrow, Lordship. I'm in the midst of another case. That's why, Lordship.
At least on 19th.
Tomorrow is 19th.
19th.
Yes, Lordship. Highly obliged.
My lord, with regards to item number 2 to 4, can you third of April?
One counsel or you?
Yes, I'm good.
Heard Mr. A. Biswas, then a counsel for the petition on request made by B. Google and the standing counsel PWD. When do you want?
On 3rd of April.
Yes, 3rd April.
Obliged, Your Lord.
Item 9 will continue.
My lord, I'd like to place 2 things, my lord, on the, my lord, page 42. It's very much important, my lord, that comments of the inquiry officer certified that I have examined each and every particulars furnished by the claimant, so and so, and all annexed relevant documents furnished with this claim and found them to be correct and beyond all reasonable doubt. I have also personally visited the unit on so and the prices mentioned in the application of land, building, plant and machinery component items with original documents and found them to be correct. Number 1. So as part of checklist, they have next page, my lord, page 43. The reference so I have the honor to forward here so sign together required enclosures as received from so and so. Second line, right? This is an existing unit and now envisages an expansion cum modernization program. The unit has submitted all the required documents as per guideline or NMPF. The GM has written, my lord, that the unit has submitted all the required documents as per guideline of so and so. So unless the record call, my lord, it cannot be verified, my lord, because the party now also I call them, they have submitted all the documents, only the COT.
Where will you get the records from? Who has the records?
Their office.
See, our office has the records we have got earlier round record was available. It was given to, it was given to the court also. Then court said they like you file an affidavit. Then on the basis of that, we have filed that affidavit. But that affidavit, lordship, that reply they have given, they have not stated a single whisper on that.
Anyway, let us see the records once.
Let us see the records. Yes, ma'am.
Otherwise,
But they have submitted or not?
Now at this stage, lordship, in my humble submission, lordship, we have given all these documents, lordship. Whatever is given, submitted later on. And like on the only that issue is the only issue is only that whether those application was complete or not. That we have this is very detailed order.
That is the reason why.
Lordship, a very detailed order has been passed stating these documents, stating that these documents are not there. We have filed an affidavit, lordship. In the affidavit, lordship, we have specifically stated this. Lordship may kindly see the affidavit.
No, that I've seen.
No, lordship, and lordship may kindly see the reply.
My party says that all documents they have submitted.
Lordship, otherwise, lordship is already
mere
said.
statement by an officer that they have not submitted cannot be taken.
I have filed an affidavit annexing those documents, showing the dates that those documents were submitted after the linking of the scheme. Then in their reply, lordship may kindly have a look at the reply, what they have stated.
Leave in the reply, they are in another single communication. There is not a single communication.
Kalita,
Not a documents.
just let us see the record for the satisfaction of
Yes,
this court as well as the petition. After that, we'll close this matter.
Yes,
If lordship wishes, I
I
can give
think
the
I have
records, but
record-
lordship, after seeing the records only, that this order was passed. and
Record there,
we have
madam.
filed an
What
affidavit,
is
lordship.
there? The black cat will come out, madam. What is there on the promise of the
One more
government?
information, lordship. On behalf of respondent number 4, lordship, need fee, lordship, we are not a necessary party, Lordship. We have no role to play.
Yes.
Even in the earlier round of litigation, Lordship, our name was struck off. Lordship, I pray that, Lordship, our name may be struck off from,
Now it's in the final stage. We
yeah.
heard and cycle and
Necessary, Lordship, we have been back in that.
on Mr. A. Kalital and the Standing Council, Industries and Commerce Department shall produce the records. I'll give a short date or you.
Lordship, I'll have to get the records because, Lordship, the whole case, Lordship, I mean, that department is itself is not
27.
there.
How long?
Department is not,
But
after the view vacation.
Speaking
Lordship.
order,
After the view
speaking
vacation.
order passed, my lord, few days back only.
List
After
after
the view vacation.
the Bihu vacation.
A date may be fixed, my lord, anyway.
I don't know how long it'll take.
Because, Lordship,
My lord, your
I
lordship may
mean,
keep
that
it
department is itself not.
pardon, my lord. or-
No, it can be kept part of it.
We'll have it on 29th. Is it okay? Is the end-
29 Lordship, it will be little bit difficult.
No, no, Bihu, before Bihu, my lord. that
No,
is
not before Bihu. Lordship, maybe on 24th or 25th, 25th.
24th.
Then 24th.
Okay, 24th April. And my lord, keeping as a pardon or my lord release?
No, I'm not keeping a spot. Anyway, I will remember this. I think
Yes.
it's a small issue.
Because it's only
Small issue, only issue, my lord, but they have not written a single letter asking for the documents.
That will be a disputed question of fact.
Yes,
Lordship, if letter is not there, if communication is not there, how they have submitted it? How they have submitted it?
That's
not
the question.
submitted,
That's
not
the same
submitted.
question
They
I
submitted
asked.
earlier. Except the COT bond, they have submitted everything.
Okay.
Obligement. Second time they have submitted. Obligement.
1. Admission, part heard matter.
Wait, please. Abba. This matter pertains to that selection of pieces under physically handicapped code. Lordship may recollect that the petitioners who were finally selected, in the final select list, their names appeared, but they are also against their names shown as provisional, and thereafter they were sent to medical board, and medical board found them not having the required degree of
Disability.
Therefore, ultimately, they were not appointed. During the panel, the new issue came up because ultimately it so happened that in the subsequent notification, recruitment notice, some of them have appeared of these petitioners, and the 29 of them got selected with the same very certificates.
Subsequent advertisement.
Yes. In a subsequent advertisement for the post of officers, 29 of these petitioners were found eligible and they got selected. Out of these petitioners, 29 got selected subsequently. And on that count, this Honorable Court wanted that how was it that you found them ineligible and subsequently found them eligible on the same very certificate? So what is your finding? Just place it. Thereupon, they have placed documents. First, the report was placed by the Education Department before this Honorable Court. This bunch of paper is there, Mali. Showing
1 minute.
uh,
Is it, how does it start, the first page?
First, it says, it gives a list. It lists from 1 to
Oh, this one, I think.
it contains also, the
First page is a letter, 2012/6/2020.
no. This is not a letter. This is what they call it. Here nothing has been written except serial number, serial in final select list, petitioner's number in WPC, name, father's name. These petitioner's names are there and they have given this.
District in court case.
District in court case.
After father's name.
District court case.
Correct.
District in court case number, serial number as per GMCH report, video number so and so, percentage as per GMCH report, category of disability as per GMCH report, then remarks against GMCH report. Here, Lordship will find that they have given 25, 26, this 29, 29
Matter name repeated.
were selected. They've found them. Which key? VH. Visually handicapped, orthopedically handicapped.
Hearing.
All these remarks column, Malad. They were found and a percentage has been shown. 40, 50, 60, all these percentages have been shown. Yeah. In the first, they have compiled this list. Petitioner wise. And then they have this submission of disability status of PWD candidates to the Director Elementary Education, Principal. This was the letter given by the Principal cum Chief Superintendent, Medical College, Guwahati and Hospital to the Director. Verification reports of 579 PWD candidates in original attendance it. So this copy was given by them. The entire the photocopies of all the candidates have been given here. Lordship may see 1, 2, 3, 4, 5, 6, 7 persons signatures appear. Designation and nothing is there. It is there. And remarks column is also there. Right hand extreme against each and every candidate. They have the remarks column. This is there. Thereafter, the health department has also submitted a report.
Same report.
Same report they have submitted here
Only for 29.
for 29 candidates.
Here.
They have given this. Lordship will find a little bit thinner than the other one. This is with the affidavit.
It's in the affidavit.
Yes, this in the affidavit dated 23/1/2025. They have given, health department has also given this report.
By respondent 4?
Respondent number 4, yes. Respondent number 4. You got it?
Yes.
Yes. So annexure they have given this, annexure is series. Here the names of the petitioners.
Page number 2497.
2497 page, my lord. Here also they have given, this was prepared subsequently, showing the names of the petitioners and remarks on everything. But here also it contains the signatures 7 signatures appear here, though signatures difficult to say that all the same signatures of the same person, but here one only deviation what I find is remarks are different from the one which was already placed in the bigger bunch of it. Remarks column here, they have come up with details something so far the petitioners are concerned, but in the original sheet, remarks column didn't contain that much, simply referring to like in one, if I may just point out. In the first page itself, Lordship will say remarks from hearing disability, PPRP, hearing witness, watching both him, hand, post trauma below knee, all these almost a single or 2 lines report is there, nothing else. Hearing disability. But in the subsequent health department, this report, it presupposes, I mean, it suggests that those remarks column, they have subsequently put in all these remarks. They have prepared it separately, petitioner wise. Obviously, this original report is the authentic in the sense that this was relating to all the 500 some candidates. And these are the 6. And this is separately prepared out of those, the bundle of selected. And here, they have given only petitioners against the petitioner's remarks column, which contains different remarks. It is there, but nonetheless, fact admitted that these 29 were found selected. It is true that these 29 were selected, they were found eligible under the quota. Under the quota. Therefore,
In the subsequent advertisement.
yes, in the subsequent. So my point was that if they were not found fit by the first one, how could they be found fit on the same very certificate by the subsequent one? Now, they admitted that yes, it is found, and they have given some logic that, well, it may improve or it may further deteriorate in some cases, this and that. But one thing is certain, that none of these petitioners were found to have no disability. Not that none of them have any disability. Only degree of disability has varied. Can I convey myself? What I mean to say is, they don't say that none or some of these petitioners are not at all disabled. They have procured a certificate which is fake. This is not the case. They say that the degree of disability varies. Earlier, in a certificate, suppose 40% is given, subsequently they say, no, we found only 30% or 20%. So they are not eligible. That apart, only 29 have been selected subsequently, that is admitted by that, yes, they are found. So also, there is every possibility that the others could have also been found. They have rejected them arbitrarily and without authority. My entire submission was that after having acted upon the certificate and declared them as finally selected, could there be any scope for the authorities to go for verification and declare them ineligible on that count? And I, referring to the laws I submitted before this honorable court, your lordship has noted down that, in fact, these certificates so granted by the designated authorities are final. There can be only appeal against those decisions. And in appeal, the appellate authority can decide what to do, how to go. But to subject them to another medical scrutiny by issuing some executive order or by an administrative direction and thereafter declaring them ineligible, it would amount to taking away the very right accrued to them on the basis of the law, Persons with Disabilities Act, giving finality and benefit of the certificate to them, which is not permissible. Which is not permissible. Act. Here, if our lordship can take up that Rights of Persons with Disabilities Act 2016. The rights of persons with disabilities. Here, lordship will kindly come to page section 56, 57, 58, 59. I will once again refer to elaborate my argument. Certification of specified disabilities. Section 56.
Yes.
This central government shall notify guidelines for the purpose of assessing the extent of specified disability in a person. So it is the responsibility of central government, the central law. This is the central law. Designation by certifying authorities. The appropriate government shall designate persons having requisite qualifications and experience as certifying authorities, who shall be competent to issue the certificate of disability. Clause 2. The appropriate government shall also notify the jurisdiction within which and the terms and conditions subject to which the certifying authority shall perform its certification functions. So, appropriate government will issue appropriate government in case of states will be appropriate government means to be definition in relation to the central government or any establishment wholly or substantially financed by that government or a cantonment board constituted under the Cantonment Act, the central government. 2, in relation to a state government or by establishment wholly or substantially financed by that government or any local authority other than a cantonment board, the state government. So it is the state government who will just designate the authority, who will issue the certificate. Accordingly, they have designated the officers under this provision. 57. And how to issue the certificate next? 58. Procedure for certification. Any person with specified disability may apply in such manner as may be prescribed by the central government. Manner is prescribed by central government to a certifying authority having jurisdiction for issuing of a certificate of disability. On receipt of an application under subsection 1, the certifying authority shall assess the disability of the concerned person in accordance with relevant guidelines notified under section 56 and shall, after such assessment as the case may be, A, issue a certificate of disability to such person in such form as may be prescribed by the central government. B, inform him in writing that he has no specified disability, either allowing or rejecting. 3, very important, the certificate of disability issued under this section shall be valid across the country. So it has given its recognition pan-India. Anywhere in any part of the country, this certificate is valid and can be relied on and acted upon. Now 59, kindly see, appeal. It will follow me here. Any person aggrieved with decision of the certifying authority may appeal against such decision within such time and in such manner as may be prescribed by the state government to such appellate authority as the state government may designate for the purpose. So appellate authority will be again designated by the state government, and one can, any person aggrieved by this certificate can make an appeal. On receipt of an appeal, the appellate authority shall decide the appeal in such manner as may be prescribed by the state government. So, my respectful submission is either granting or rejecting a certificate. If someone is aggrieved, any person can make an appeal, and appellate authority is there to judge, to inspect, to peruse the records, and if necessary, to go for re-verification. Otherwise, the certificate will stand. Only appellate authority can vary the certificate. After recording a finding, after proper verification, perusal, and hearing the parties, if necessary, they can go to the extent of verifying the disability, degree of disability. And then can say the certificate is rightly issued or wrongly issued or it needs variation. Otherwise, the certificate prevails. It cannot be just ignored. It just cannot be ignored by any authority, however high he may be, or whoever he. This certificate carries the sanctity of law. It cannot just be thrown out. No, I will not regard it. Otherwise, there will be total chaos, lawlessness. And what is happening is that here. I will respectfully submit. Now, what is the power of the state government here? They will designate the authorities. Manner will be prescribed by the central government. So guideline is issued by the central government. What power is left to the central state government is to make rules. For what? Can you see that provision? 101 section. Power of the state government to make rules. The state government may, subject to the condition of previous publication, and a note, subject to the condition of previous publication, by notification, make rules for carrying out the provisions of this act, not later than 6 months from the date of commencement of this act. Within 6 months, they are bound to make it. Now, 2. In particular, and without prejudice to the generality of foregoing powers, such rules may provide for all or any of the following matters, namely, A. The manner of constituting the committee for research and disability under subsection 2 of section 5. The matter of providing support of a limited guardian under subsection 1 of section 14. C, the form and manner of making an application for certificate of registration under subsection 1 of section 51. The facilities to be provided and standards to be met by institutions for grant of certificate of registration under subsection 3 of section 51. It speaks of the facilities to be provided and standards to be met by the institution for grant of certificate of registration under section 51. E, the validity of certificate of registration, the form of and conditions attached to certificate of registration under subsection 4 of section 51. This validity of certificate of registration indicates the certificate issued to the authorities, institutions who are authorized to issue certificate. If a Lordship kindly look at 51, Lordship will find section 51. Here, before that, Lordship will see 49 and 50 also. Competent authority. This chapter 9 begins with registration of institutions for persons with disabilities and grants to such institutions. Competent authority. The state government shall appoint an authority as it deems fit to be a competent authority for the purpose of this chapter. Registration. Save as otherwise provided under this Act, no person shall establish or maintain any institution for persons with disabilities except in accordance with a certificate of registration issued in this behalf by the competent authority, provided that an institution for care of mentally ill persons which holds a valid license under section 8 of the Mental Health Act 1987 or any other act for the time being in force shall not be required to be registered under this Act. Now 51. Application and grant of certificate of registration. Every application for a certificate of registration shall be made to the competent authority in such form and in such manner as may be prescribed by the state government. On receipt of an application under subsection 1, the competent authority shall make such enquiries as it may deem fit, and on being satisfied that the applicant has complied with the requirements of this Act and the rules made thereunder, it shall grant a certificate of registration to the applicant within a period of 90 days of receipt of application, and if not satisfied, the competent authority shall, by order, refuse to grant the certificate applied for, provided that before making any order refusing to grant a certificate, the competent authority shall give the applicant a reasonable opportunity of being heard, and every other refusal to grant a certificate shall be communicated to the applicant in writing. No certificate of registration shall be granted under subsection 2 unless the institution with respect to which an application has been made is in a position to provide such facilities and meet such standards as may be prescribed by the state government. So they will have to have some facilities, otherwise no. Therefore, registration here means only those institutions which can be authorized to grant certificate. They need registration. Therefore, this E, rule E, validity of certificate of registration, the form of and condition attached to certificate of registration under subsection 4 of section 51. That rule they can make, what facilities they should provide, how the institution should be formed, all that. Now, the period of disposal of application for certificate of registration under subsection 7 of section 51, the period within which an appeal to be made under subsection 1 of section 53, that is regarding the period of limitation, the time and manner of appealing against the order of certifying authority under subsection 1 and manner of disposal of appeal under subsection 2 of section 59. This is time and manner of appealing against the order of certifying authority. Here, if someone wants to appeal, how to make appeal, time and manner, how to make this procedure should be prescribed by the state by making rules. The allowance to be paid to nominated members of the state advisory board, the rules of procedure for transaction of business in the meeting of the advisory board, the composition and functions of the district level committee, salaries, allowances, and other conditions of service of the state commissioner, salaries, allowances, and condition of service of officers and staff of the state commissioner.
Is it necessary to go through?
Nothing. I am taking a lordship to everyone because knowing it, these are not, none of them are applicable. There is no rule, but the rule doesn't provide any power to them to say anything, to make any rule in respect of issuance of certificate, disability certificate, or laying down guidelines of issuing certificate. Okay. This is only by the central government. Central government had issued those guidelines. They will only designate the authority who will do it. They will only designate the appellate authorities who will hear appeal. And procedure of making appeal. Time limit fixed. That much. Therefore, my contention is that there is no such power. When there is no such power, can the state government or any state authority just refuse to recognize or take note of or easy left with the right to doubt the veracity of the certificate? What is the position? Therefore, my respectful submission is the authority here acted beyond their authority, and all illegal actions are required to be interfered with. Central government rule is there, Rights of Persons with Disabilities Rule 2017. In this rule itself, people will find these are there. In these rules, Lordship will find, Lordship has got the rules, central government rules. Certificate of disability. Kindly come to section rule 17.
Yes.
Any person with specified disability may apply in Form 4 for a certificate of disability and submit the application to a medical authority or any other notified competent authority to issue such a certificate in the district of residence of the applicant as mentioned in the proof of residence in the application, or the concerned medical authority in a government hospital where he may be undergoing or may have undergone treatment in connection with his disability. Provided that where a person with disability is a minor or suffering from intellectual disability or any other disability which renders him unfit or unable to make such an application himself, the application on his behalf may be made by his legal guardian or any organization registered under the Act having the minor under its care. The application shall be accompanied by proof of residence, 2 recent passport size photographs, and Aadhaar number or Aadhaar enrollment number if any. Note, no other proof of residence shall be demanded from the applicant who had Aadhaar or Aadhaar enrollment number. Issue of certificate of disability, 18. On receipt of an application under Rule 17, the medical authority or any other notified competent authority shall verify the information as provided by the applicant and shall assess the disability in terms of the relevant guidelines issued by the central government. And after satisfying himself that the appellant is a person with disability, issue a certificate of disability in his favor in Form 5, 6, and 7, as the case may be. The medical authority shall issue the certificate of disability within a month from the date of receipt of the application. 3. The medical authority shall, after due examination, issue a permanent certificate of disability in cases where there are no chances of variation of disability over time in the degree of disability, or issue a certificate of disability indicating the period of validity in cases where there is any chance of variation over time in the degree of disability. So in such case, they will specify the period. It will remain valid for 5 years. Normally they do it. If an applicant is found ineligible for issue of certificate of disability, the medical authority shall convey the reason to him in writing under Form 8 within a period of 1 month from the date of receipt of the application. So, in the case of rejection of the application, if they say that he is not eligible, in that case, reason should be given. The state government and union territory administration shall ensure that the certificate of disability is granted on online platform and such date from such date as may be notified by the central government. Now it is on online platform it is granted. 19. Certificate issued under Rule 18 to be generally valid for all purposes. A person to whom the certificate issued under Rule 18 shall be entitled to apply for facilities, concessions, and benefits admissible for persons with disabilities under schemes of the government and of non-government organizations funded by the government. 20. Validity of certificate of disability issued under the Repealed Act. The certificate of disability issued under the Persons with Disabilities, Equal Opportunities, Protection of Rights and Full Participation Act in 1995 shall continue to be valid after commencement of this act for a period specified therein. Therefore, the whole procedure is laid down and the certificates are obtained accordingly. There was no appeal made, no finding recorded by any appellate authority against any of these petitioners' certificates. Now then, what prompted the authority to say no to us? They say that some doubt arose, somebody lost some complaint that some persons with they have said something somewhere. No complaint as such has been placed on record. Nothing. Nothing. Who lost complaint? What complaint? What created doubt? They raised some doubt. They raised some doubt that, well, there may be fake certificates. So they decided to go for re-verification of it. When time is crucial. In our case, they say they have submitted some document here later on. They have placed one document here.
Where?
Yes. Lordship will find that office memorandum dated 21st May 2022.
Loose document.
Yes.
Evening. Okay. What is that? Oh. Is it there, my lord?
Yes.
This is dated 21st May 2022. Subject: reservation of post for persons with benchmark disabilities and other concessions. In pursuance of the right of persons with disabilities Act 2016 and in supersession of office memorandum issued in this regard, video number so-and-so dated 7/1/2019. The following instructions are issued regarding reservation of reservation for persons with benchmark disabilities as defined under Section 2R of the Act against the post and services of the state government. Now, kindly come to this was, they say, in pursuance of the right of persons with disability Act 2016, they have issued. What they have to say here? Kindly see at the next clause 5, serial 5. certificate of disability. A person who wants to avail the benefit of reservation will have to submit a certificate of disability issued by a competent authority. Such certificate, in the event of selection of such person for any post, will be subject to such verification, re-verification, as may be decided by the competent authority. They will be taking shelter to this particular memorandum, clause 5. Firstly, let us see when was this issued. As you have seen, this was issued on 21st May 2022.
Final select list was declared.
Now, when was the post advertised? Our posts were advertised
18/9/21.
18/9/21. When was selection held?
11/5/22, final select list.
Final select list was published on 11/5/2022. 11th May.
After that,
11th May.
May.
Then, when this final list was published, they issued a direction that there will be a medical board for verification, re-verification. We were asked to appear before.
That is of 19/5.
That was on 19/5/2022. This death circus here.
Okay, once more.
Yes.
Advertisement.
Advertisement dated 18/9/2021.
Yes.
Final select list dated 11/5/22. Final advertisement dated 18/9/21. Final select list 11/5/2022.
Final select list dated 11/5/2022. And medical notice was issued on 19/5/2022.
Yes.
By this notice, we were required to report to the medical college.
For re-verification.
For re-verification. And this memorandum was issued on 22nd May 2022.
21st May.
21st May, sorry. This was 21st May 2022. So this has no retrospective effect. This could not have been applied or is not applicable to our case, if at all. Without considering it, considering its legality. Without considering its legality, it can straightway be said that this cannot have a retrospective effect. Much before the issuance of this notification, final list was done. Some appointments were issued, only we were held up. Game was over. Therefore, taking recourse to this notification, they could not have rejected our case. It would amount to changing the rules of the game at effect. No, at no point of time, nowhere, ever, the authority indicated that even if you are selected on the basis of this certificate, you may have to go for re-verification. Nowhere. This was never said, no indication. If I take your lordship again, lordship has taken note of my argument. It will take time, otherwise if I can take your lordship to this, but then cut short, nowhere. It ought to have been mentioned in the advertisement itself. Thereafter also, they would have indicated nothing, nowhere. Only says that those having disability, they will get the reservation as per law. And they must have a certificate to apply. Applied, selected, round of few rounds of selection in the process they call it. কি বুলি কয় সেইটো এটা এটাকে আহি থাকে যে একবাৰে verification. First verification, second verification, and final selection. They verify the records, credentials on 2 rounds. Then they go for final selection. This is the process. And at no point of time they said this. Only in the final select list, when they put provisional against our name, we raised doubt. What happened? As I submitted earlier, final select is this final. You could not have enlisted these names with the remark provisional. Provisional remark is irrelevant in final select. Before that, you should have taken the course, whatever was required to screen those candidates. You cannot. This is not the process. Service jurisprudence doesn't say this. It doesn't prescribe. This is not the procedure. Therefore, this has no bearing in our case. They could not have fallen back on this to say that we have this power, we have done it. As I said, without considering its legality. Now, if we look into the legality, whether this variation could have been laid down under the law, rule-making power we have seen, it doesn't prescribe. It doesn't prescribe that they may they may make rule regarding verification, re-verification, and anything subsequent to the grant of the certificate by the designated authority. What is that? Law doesn't provide that in case of verification or re-verification, who should constitute the board? Who will constitute the board? What board will be constituted? Who will be there? These are all issues to be looked into. Simply saying that no, I doubt it, and I ask, well, you form a committee and re-examine them. Is it permissible? In my assumption, no. Therefore, the legality of this notification is at stake. Had it been issued previously, had it been known to us, probably we could have challenged it that time. It has no legal validity. But this has been issued after the game was over. Now they've come, place it before the court that, well, this is the. Otherwise, why they are bringing it? They will say this. In my full submission, they cannot. They cannot rely it in our case. And we challenge the legality of this notification also. Apparently, on the face of the provisions of the Act as in the rules, not sustainable.
Given by that.
Now, that being the position, my lord, one thing is very certain now, that they have themselves contradicting their first report, whereby we were nullified, all the petitions were nullified, rejected. Subsequently, they have considered that yes, out of them, 29 have been found fit. So, their percentage of disability mentioned there were almost similar to the said percentage which were mentioned in our certificate, original certificate. Therefore, that the process was not very fairly conducted. This is very clear. Very clear. The reports, as we have challenged in our petition, we have said that even for we appeared, just ask us where from you are, what is to do, what is your sufferings. Nothing, no test was carried about only by one doctor. It was not sent, they were not sent to respective specialists of the department to verify. Not that they all sat in a group. This is our case. They all sat in a board and examined us there with apparatus and everything, not there. And the report has been submitted, the final report volume, that in a remarks column, Lordship has seen they have just passed a comment, nothing. How it was done, who are those persons who were there, nothing is there. Therefore, these documents itself presupposes that all were not well, notwithstanding the legal sanctity of the process adopted or followed by the authority. Therefore, by responsible submission, this certificate stands. Those certificates are not nullified, not declared as invalid. So, we are entitled to the benefit of the certificate, and they are bound to appoint us. Now, they are bound to appoint us.
Are you pressing for the other 29 who got selected in the other case?
It is join কৰিলে নেকি 29? কেইজনমানে কৰিছে। Well, out of the 29, most of them have joined. Only 2-3 persons, they are waiting for this.
Okay.
Otherwise, those who have joined. It is for them to come back or not to come. Those who have not joined, if they are waiting, they may have the option provided the court grants with them. Now, well, then in that case, one may raise the argument that what remains if we cannot look into it, if we find that the certificate is not really genuine, then a person with ingenuine certificate will continue. One can raise this argument. My response submission would be, you just cannot, on presumption or on doubt, deny the benefit under the law. So you will have to give the benefit. But subsequently, if you can gather informations, concrete informations, that someone has played fraud on you, giving false information, procuring something falsely, then you always have the remedy. You can always proceed, remove, terminate, do anything you like. But without having these materials in hand, simply on doubt, you cannot deny the right that has been accrued under the law. It is a fundamental right under Article 14, 16, and 21, and a legal right under the Disabilities Act. So, benefit once he is entitled under the Disabilities Act, if he is otherwise found fit by following the due process, you cannot. You cannot do it. It will amount to taking away his right, fundamental right of getting the appointment. That is my responsibility. They have relied upon few decisions. I will just refer to. They have relied upon the decision in WPC 2995 of 2024, Bhanita Das versus the state of Assam. Lordship has got this, Lord.
Dinesh Das, no.
Bhanita Das. This is by a collateral bench of this court, Justice Kalyan Rai Surana. Honita Das. You couldn't see them comments. Health, education.
You have an extra copy?
Two 995 of 24.
Found in my idea, no? FIS. কত ভালো ভালো লেগেছিল কখন পাই অনিতা দাস
Oh, this one here. Yes, yes, yes.
Yes, my lord. Yes. So here, kindly see the facts of this case. Paragraph 3. The case of the petitioner got it, my lord?
Yeah.
Yeah.
Yes.
Paragraph 3, my lord. The case of the petitioner is pursuant to a recruitment advertisement dated 25/3/2022, issued by the Secretary State Level Recruitment Commission for Class 4 post. The petitioner had submitted her online application for filling up 13,300 numbers of vacant grade 4 posts under the category of persons with benchmark disabilities. Hereinafter referred to as PWBD of 4. The recruitment was to be done as per Assam District Recruitment for Class 3 and 4 Analogous Post Rule 2022. The petitioner has cleared the written examination held on 21/8/2022 and was declared qualified for the next level of test. Thereafter, she had appeared in the interview held on 11/1/2023. The petitioner was declared qualified as per the provisional result published by the SLRC on 4/5/2023. In the provisional result of Class 4 issued by the SLRC, it is clearly mentioned in bold letters that in case of PWBD category appointment shall be confirmed after medical examination and clearance received from medical board. Accordingly, she has become eligible for appointment. Subsequently, as per the randomized posting result for SLRC grade 4 recruitment that was published on 9/5/2022, the petitioner was recommended for appointment in the post of Chokidar in the establishment under the Secondary Education Department, Government of Assam. By virtue of notice published on 12/5/2023, all the recommended candidates were asked to appear before the Medical Education and Research Department for the benchmark disability of the successful PWD candidates. It is projected that on the appointed date and time, the petitioner has appeared and subjected herself for the medical re-verification that was conducted at Guwahati Medical College and Hospital. The result of medical re-verification was declared in newspaper on 22/5/2023, wherein the petitioner's name did not appear. Thereafter, video notice dated 6/6/2023 issued by the Principal Secretary, Department of Social Justice and empowerment, all candidates with benchmark disability who did not qualify in medical re-verification were called upon to file an appeal by 6/6/2023. Accordingly, the petitioner has preferred an appeal before the Principal Secretary, Department of Social Justice and Empowerment. Thereafter, by an advertisement published on 27/7/2023, all PWD candidates, category candidates who had filed appeal were asked to reappear before the medical board at GMCH on the scheduled date mentioned in the notice. The petitioner again appeared before the medical board GMCH for her medical re-examination. However, again the name of the petitioner did not appear in the result declared on 19/8/2023, whereby the list of candidates who had cleared the test was notified. The petitioner then approached the court by filing a writ petition. The court, by order dated 18/12/23, disposed of WPC so directed the respondents to communicate the individual disability status to the petitioner against the post she had applied for. The petitioner claims that on 3/4/24, she was handed over a communication dated 8/2/24, issued by the Joint Secretary to the Government of Assam Department of Social Service and Empowerment, by which her disability status as assessed by GMCH on 2/8/2023 was to the effect that her hearing impairment was 14.66%. The case of the petitioner is that in the employment advertisement, there was no disclosure of the terms and conditions that a PW candidate would have to appear for medical verification. In this context, the learned counsel for the petitioner submitted that the process was discriminatory as candidates other than PWD were not required to undergo medical examination. It was submitted that disbelieving a certificate of disability of PWD is also discriminatory. It was also submitted that as per government notification dated 13/9/2023, the medical board was required to be constituted by principal cum chief secretary, chief superintendent of the concerned medical college for the purpose of report, and its report would be final and binding. Hence, it was submitted that the constitution of the medical board was illegal. It was further submitted that as per the disability certificate dated 8/7/2021 issued by the competent certifying authority, the petitioner was suffering from permanent hearing impairment disability, and the percentage of disability is 100%. It was also submitted that instead of notifying rules within 6 months, as envisaged under subsection 101 of Rights of Persons with Disabilities Act 2016, the state government had been following 1. Clause 5 of the OM dated 21/5/2022, as well as another notification dated 13/9/2023, whereby powers were reserved for reassessment of benchmark disability and cancelling the certificate issued by the competent court. It was submitted that a fresh advertisement dated 27/10/23 has been issued for filling up 5,000 tentative vacant grade 4 post under different departments, envisaging reservation of PWD category. Accordingly, it was submitted that while issuing notice, one advertised post for PWD category be kept vacant. The submissions of the learned state and the departmental council has been heard. Opposing the admission of this writ petition, an interim prayer made by the petitioner, the learned standing counsel for respondent number 5 had placed reliance on the case of State of Uttar Pradesh versus Ravindra Kumar Sharma, 2016 4 HCC. It is not in dispute that before the petitioner was provided with an offer letter to join in service, she was asked to undergo medical re-examination. However, in such re-verification, she was not diagnosed as a person having benchmark disability. It is admitted by the petitioner that she had collected her disability status as assessed by GMCH, whereby her hearing disability was assessed as 14.66%. Be it mentioned that in para 11 of the writ petition, the petitioner had not assailed provisional result of class 4 issued by SLRC for class 4 post. Notice published on 12/5/2023, addressment dated 6/6/2023, by which the petitioner was asked to appear for medical verification. Notice published on 19/8/2023, requiring the petitioner to appear for her medical verification. By the order dated 18/12/2023, passed by this court on Iman, filed by the petitioner, she was granted liberty to assail the decision of the Medical Board, Department of Social Justice Empowerment, fresh writ petition. In said writ petition, the petitioner had not assailed provisional result of class 4 issued by SLRC. Notice published 12/5/23, advertisement dated 6/6/23, by which the petitioner was asked to appear for medical verification. Notice published on 19/8/23, referred to above. Hence, the court is constrained to hold that the petitioner had waived her right to challenge the constitution of the medical board. By allowing this court's order dated 18/12/23, passed in WPC 7323 of 23 to attain finality, the petitioner had abandoned challenge to the constitution of the medical board and or to challenge provisional result of class 4 and SLRC post. Notice published on 12/5/23, advertisement dated 6/6/23, by which the petitioner was asked to appear for medical verification, or notice published on 19/8/2023. Therefore, the principle of constructive res judicata would be squarely applicable in this case, and the petitioner cannot be permitted now to turn around and lay a challenge to the petitioner in which the medical board was constituted, which she has waived and or failed to challenge in her previous petition. It is well settled that having appeared in a selection process, it is not permissible for an unsuccessful candidate to turn back and challenge the selection process. If one needs any authority on the point, case of the Saroj Kumari versus Helen Thailokom, 2017 9 SSC, decided by Supreme Court. I'll be pausing for a moment here. This observation or this finding is not applicable in our case, because here we have come challenging the very process. We have our categorical cases that they could not have sent us, and our participation would not be to our disadvantage. Firstly, to be seen, I am a job seeker. We are already selected. Certificate is there. They ask us to go before notification, you go and appear before that. It may be a police verification type thing. Physical fitness required in case of all for government job. Thereafter, they should notice. Had there been this notice that it would be required to appear, then we could have challenged it. That is why I said that this office memorandum that was placed, that was not known to us, that was not given to us. This was after the process was over. After the process was over. Therefore, these principles are not at all applicable. And in our case itself, the court directed, this honorable court directed that you give details individually. Who was considered how? Instead of giving that, they have given that bundle. Lordship has seen how they have assessed it. How they have assessed it. Simply one line, 2 words, 3 words remark. That much. Nothing. Can it be said that this is an expert committee report? Expert committee report will constitute findings, test reports, findings, everything. Then only they will conclude in their concluding remark what is the status ultimately regarding the degree of disability. Nothing. If on medical re-verification conducted at GMCH, the percentage of hearing impairment of the petitioner is assessed at 14.6, the petitioner cannot be said to be entitled for claiming appointment under PW category. This is not a case where the appropriate government, after conclusion of the recruitment process, had declared certain percentage of specified disability as benchmark disability and appointed persons on pick and choose basis. Hence, it cannot be said that there was an discrimination against the petitioner in any manner whatsoever. Question of Malad here, with all respect, after conclusion of the recruitment process had declared certain percentage of specified. It is not a case where the appropriate government, after conclusion of the recruitment process, has declared certain percentage of specified disability as benchmark disability. This is not the case. When the state government cannot declare, it is the power of the central government. Minimum 40% disability. They can only say what will be the process, how it will be procured. Otherwise, they cannot. Therefore, this question of laying down a fresh degree of disability by the state government before conclusion is something else. It is not here. Nowhere they can do. Not that. It was not done. Here also nowhere. They simply send back these persons for medical re-verification. Whether this is permission. This is the issue. The learned judge has gone to a certain extent in my hospital submission which are not attracted here. Thus, paragraph 17. Sixth line, thus it appears that this is not a solitary case where upon re-verification, the percentage of disability was not found in consonance with the disability certificate held by the successful candidate. The Supreme Court case has been referred to. We'll come to this small state of Uttar Pradesh versus Ravindra Kumar. This case has been referred to here at referring to paragraph 2, 3, 5 has been referred to, then 10. The division bench of the High Court has ignored and overlooked the material fact that verification has already been done by the medical board, and it has been found that certificate of 21% were fraudulently obtained. The High Court has issued a direction in the impugned order for physical verification of the candidates by the authorities, and in case he does not suffer from disability, so certified candidate can be subjected to fresh medical test. We'll come to it later on, Mallar. I will take up this case. I have the book citation. I will place it from there. But let us, citing this case, State of Uttar Pradesh versus Ravindra Kumar, the court has said, our court has said, thus in view of the above, as the disability of hearing impairment suffered by the petitioner is assessed on re-verification to be 14.66%, thus a disability cannot be said to be a benchmark disability. Moreover, similar to the case of Uttar Pradesh, several candidates have approached this court to assail the lesser degree of disability, which is sufficient to demonstrate that the decision of the competent authority to get the disability reassessed cannot be faulted with. the power to do so such verification flows from the OM dated 21/5/2022, which is impugned in this writ petition. So, my lord, the power, they, in that case also, they said the power flows from the notification office memorandum dated 21/5/2022, Lord Chief Unit. As I have said, that this was subsequent, in our case, this was subsequent to the medical notification. Thereafter only. Yeah. Prior to that, this power was not there. So on the date when they acted upon, there was no power even by this notification was not issued. Under the facts of this case, on a consideration of the decision of the Uttar Pradesh, that case has not been able to make out a case. 22. On re-verification, the petitioner is not found to be suffering from benchmark disability, and yet it is selected and appointed in grade 4 post on the strength of medical certificate showing her to be suffering from benchmark disability. Then the petitioner would be infringing the right of a candidate who, upon medical re-verification, is found to be suffering from benchmark disability. That would be more unjust and iniquitous to persons actually found on medical re-verification to be suffering from benchmark disability. My lord, all these discussions can be considered otherwise also. If after verification they are found to be eligible, some of them at least for some other post, then what would have been the situation when they are denied here? Their right is infringed. Petitioner's right has been infringed. Twenty-five PA2. Result. Acha. Moreover, it no longer is implicated that after selection process is concluded, subsequent vacancies required to be filled up by fresh recruitment process. So, my lord, we need not go to all these things. It was in the motion stage itself. It was disposed of. So, it is subject to that facts of that particular case without going for a thorough hearing, giving opportunities to the persons to place on records. Now here, Lordship has seen a lot of exercise has been done by now. They have placed the records. All those reports have come. How they have considered those reports, that is also before this honorable court. What are the findings of those two medical boards separately? And who constituted this board? How can this be done? And when was this done? And by that time, what was the power available? When more particularly the 22, that of May 22, 2022 notification was much later than the final selection was over. So, that Bhanita Das in my respectful submission has no bearing here. Lordship will kindly take up that state of Uttar Pradesh versus Ravindra Kumar Sharma. What is the case about? We will have to see. In this case, fraud was alleged. A complaint was received. Not you got it? No? Yes. I will place first paragraph 1. Leave granted. The question involved in the appeal is as to the right of the appellant to verify the disability certificates. Issue is this. The right. This is an appeal by the state.
Thank you.
This is an appeal by the state of Uttar Pradesh. Leave granted. The question involved in this appeal is as to the right of the appellant to verify the disability certificates issued by the medical board under the provisions of the Pension Persons with Disabilities, Equal Opportunities, Protection of Rights and Full Participation Rules 1996. The respondents applied for BTC training course under the physically handicapped category on the basis of certificate issued by the aforesaid rules. It was claimed that they completed the training and had been offered appointment in the primary schools run and managed by the state government. A complaint was received. Kindly see, a complaint was received from Bharatiya Viklang Sangh of illegal usurpation of the quota reserved for handicapped persons on the basis of fraudulently procured certificates without suffering from the disability certified under the rules of 1996. The state government issued an order dated 3/11/2009 making a provision for constitution of fresh medical board in order to verify and assess the disability of the candidates. The candidates questioned the communication dated 15/7/2010 issued by the Director, State Council for Educational Research and Training based upon government order dated 3/11/2009 requiring them to appear before the medical board constituted in order to assess the disability. Out of the 234 candidates selected under the handicap category, on being examined by the medical board, it was found that 21% of the candidates were not handicapped. Here, they were found to be not handicapped, 21%. Here, in our case, well, none has been found to be not handicapped, but only degree of difference of the disability. A single bench of the High Court of Allahabad hit a judgment and order dated such and such dismissed the writ application, holding that under the rule framed in exercise of the powers under subsection 1 and 2 of section 73 of the Persons with Disabilities Act 95, the general eligibility to apply for the facilities, concessions and benefits admissible under the scheme for the Act is subject to such conditions as the state government may impose, and the state government has imposed a condition in the order dated 3/11/2009 of Constitution of the Medical Board for verification of the disability. Even otherwise, under the rules, there can be a review of the decision upon representation by the applicant, and a fresh order can be passed. Thus, the certificate issued is not final. Here, my lord, court says, even otherwise, under the rules, there can be a review of the decision upon representation by the applicant, and fresh order can be passed. Thus, the certificate issued is not final. That means, subject to review, it is final. Subject to review. It can be reviewed because appellate power is there. Otherwise, it is final. Law says. On appeal being preferred, a division bench of the High Court of Allahabad by the impugned order has allowed the appeal and has held that while the certificate has been issued in accordance with the rules of 96, roving inquiry cannot be made until and unless fraud has been detected. It is not permissible to reopen medical certification carried out under the rules of 1996. However, the High Court has directed that a physical verification may be made, and if the candidate has not been issued certificate of disability or otherwise, or that he does not suffer from any disability so certified which entitles him to such a certificate, in that event, the candidate can be subjected to fresh medical test and not otherwise. Accordingly, the direction of the government in the order dated 3/11/2009 and by the director on 15/7/2010 of physical verification be construed in the appropriate manner. It is apparent from the rules of 1996 that disability certificate is required to be issued by the medical board. It can issue permanent disability certificate, or the medical board shall indicate the period of validity in the certificate in case where there is any chance of variation in the degree of disability. In case of refusal of disability certificate, an opportunity is required to be given to the applicant of being heard and there can be a review by the medical board on representation by the applicant, and the rules contain a provision to the effect that the certificate issued by the medical board shall make a person eligible to apply. In the facts of the instant case, there was a serious complaint, kindly note this, man. There was a serious complaint lodged by Viklang Sangh of illegal usurpation of the quota reserved for specially able by a large number of persons who were not in fact specially able and have procured certificates fraudulently from their district under the rules of 1996. On the basis of said complaint, the government has issued an order for the purpose of verification of such certificate issued by the medical board. And the certificates of 21% of selected candidates of handicapped category were found to be fraudulent. It is subtle proposition of law that fraud vitiates, and in such a case, when a large number of candidates have illegally usurped the reserved seats of the persons suffering from disability, the action of the state government did not call for interference. In Sasansas versus Sasansas, it was observed, Lord Denning has been quoted, no judgment of a court, no order of a minister can be allowed to stand if it has been obtained by fraud. Fraud unravels everything. In the same judgment, Lord Parker, learned judge, observed that fraud vitiates all transactions known to the law of however high a degree of solemnity. These aspects were recently highlighted in State of AP versus Suryashand Rao. In Ramchandra Singh, regarding all fraud, it is quoted, fraud, as is well known, vitiates every solemn act. Fraud and justice never dwell together. Fraud is a conduct, either by letter or words, which induces the other person or authority to take a determinative stand as a response to the conduct of the former, either by word or letter. It is also well settled that misrepresentation itself amounts to fraud. Indeed, innocent misrepresentation may also give reason to claim relief against fraud. A fraudulent representation is called deceit and consists in leading a man into damage by willfully or recklessly causing him to believe and act on falsehood. It is a fraud in law if a party makes representations which he knows to be false, and injury ensures therefrom, although the motive from which the representation proceeds may not have been had. An act of fraud on court is always viewed seriously. A collusion or conspiracy with a view to deprive the rights of others in relation to a property would render the transaction void ab initio. Fraud and deceptions are synonymous. Then, my lord, kindly come to next page. 2956. Suppression of a material document which affects the condition of service of the petitioner would amount to fraud. In such matters, even the principles of natural justice are not required to be complied with in such a situation. Now, 9 paragraph. They have quoted Express newspapers. Fraud on power voids the order if it is not exercised bona fide for the ends of design, for the end design. There is a distinction between exercise of power in good faith and misuse in bad faith. The former arises when an authority misuses its power in breach of law, say by taking into account bona fide and with best of intention some extraneous matters, or by ignoring relevant matters. That would render the impugned act or order ultra vires. My lord? Lordship?
Carry on.
Sorry?
Carry on.
Para, my lord, para 9. Para 9, my lord. Para 9 has quoted the judgment of the Newspapers Private Limited versus Union of India. There, the fraud was pleaded. That is how the court, what it says at page 11, paragraph 119. Fraud on power voids the order if it is not exercised bona fide for the and design. By being in power, if the power is not exercised for the end design, then it amounts to playing fraud on the power. There is a distinction between exercise of power in good faith and misuse in bad faith. The former arises when an authority misuses in its power in breach of law, as has been done here. Say, by taking into account bona fide and with best of intention some extraneous matters or by ignoring relevant matters. You can act bona fide, but best of intentions, extraneous matters are taken into account or ignoring the relevant materials. Then also it amounts to fraud. That would render the impugned act or order ultra vires. It would be a case of fraud on powers. The misuse in bad faith arises when the power is exercised for an improper motive, say to satisfy a private or personal grudge or for wreaking vengeance of a minister, as in S. Pratap Singh versus State of Punjab. A power is exercised maliciously if its repository is motivated by personal animosity towards those who are directly affected by its exercise. Use of power for an alien purpose other than the one for which the power is confirmed is mala fide use of that power. Same is the position when an order is made for a purpose other than that which finds place in the order. The ulterior or alien purpose clearly speaks of the misuse of the power, and it was observed as early as in 1904 by Lord Lindley in General Assembly of Free Church of Scotland versus Lord Overton, quote, that there is a condition implied in this as well as in other instruments which create powers, namely that the powers shall be used bona fide for the purpose for which they are conferred. Again, quoting Warrington Chief Justice says, no public body can be regarded as having statutory authority to act in bad faith or from corrupt motives, and any action purporting to be that of the body but proved to be committed in bad faith or from corrupt motives would certainly be held to be inoperative. The division bench of the High Court, paragraph 10, madam. The division bench of the High Court has ignored and overlooked the material fact that verification has already been done by the medical board, and it has been found that certificates of 21% were fraudulently obtained. The High Court has issued a direction in the impugned order for physical verification of the candidate by the authorities, and in case he does not suffer from the disability so certified, the candidate can be subjected to fresh medical test. The High Court has overlooked that on mere physical verification, it may not be possible to know various kinds of disability, such as that of eyes, ear impairment, etc. That can only be done by the medical examination, and particularly when the High Court itself has observed that in case there is genuine suspicion and fraud has been committed, medical certification can be reopened. This is the condition, my lord. If there is genuine suspicion that suspicion and fraud has been committed, medical certification can be reopened. Direction issued in this regard has not been questioned by the respondent, and in fact, process of re-verification was already over when the High Court issued the appropriate directions. This was the direction of the High Court in division bench. So court said that it was already done, so let it be done. In our considered opinion, in the peculiar facts of this case, of such a fraud and genuine suspicion raised in the representation lodged by the Viklang Sangha, And when 21% of such certificates have been found to be fraudulently obtained, there was no scope for the division bench to interfere and issue order to perpetuate fraud. Writ is to be declined in such a scenario, and no equity can be claimed by the respondents. In that particular facts, because here there was a definite complaint by Biklang Sangh. So court says that in case of such a fraud and genuine suspicion raised in the representation lodged by Biklang Sangh, definite complaint should be. In these circumstances, we set aside the impugned judgment and order passed by the division bench of the High Court and dismiss the writ petition. Last 4 lines are important. However, before taking any action against the individuals, they shall be issued so cause in the matter, and thereafter decision will be rendered in accordance with law. Let this exercise be completed within a period of 4 months. The appeal is allowed to the appropriate. My argument that they have acquired a very vital right that cannot be taken away. This is being emphasized here in this line, 4 lines. Here, those petitioners were already selected. They have undergone training, and thereafter they were selected for appointment. That time, that complaint came. Thereupon, the verification was made. 21% was found to be fake, fraudulent, definite. That was. Now they will suffer therefore, but that was on the basis of a complaint. That complaint, anonymous complaint, or say by Biklang Sangh, complainant's complaint, simply acting upon, they cannot be deprived of their right. Therefore, Supreme Court says, now you can take action against them. Either you cancel their candidature or proceed otherwise, but that should be done by giving a notice to them, giving them an opportunity of hearing. By issuing a notice, you, accordance with law, you are to take a decision ultimately, not other. Therefore, I submitted, my lord, in our case also, when they were finally found fit and selected, and now there is discrepancy amongst the medical boards also, not telling with each other. So they are to be appointed. They are to be appointed. How can that right be taken away from them? And thereafter, you always retain the authority to proceed against them if you have some specific allegation, specific suspicion, definite case against anybody. This is always there with them. Under the disciplinary appeal rules, they can be proceeded against. Or otherwise, you played a fraud, giving false information. Why not you shall be terminated? That notice would be enough. But simply because somebody has thought of that a re-verification is required, because there may be some fake person. That is only an assumption. That cannot be the ground to act or go against the law. Here, in this case, definite allegations were there, therefore they acted upon. It is not an anonymous letter. The Biklang Sangh raised this. So if it asks for that you give documents, if you have anything, any information with you, we will proceed on it, that can be given. But here is nothing. Here is nothing except where they say, it would be. What say in the annexure A?
The affidavit opposition filed by the.
Affidavit of opposition filed by
Yes.
S1 number 4.
Filed on 11/3.
It was filed on 11/3. ক'ত আছে সেইটো use কৰিছিল নহয় ঘৰত। সেইটো নহয় তাৰ অৰ্থত কৈছিলে Lordship got it, my lord. 2560 page, my lord. 2560. Hmm? 257. Hmm?
By respondent number?
4.
Oh, okay.
You're gonna page to কেনেকে মিলা নাই?
2510. এখন পেলে জেলাখন ফাইল কৰিছিলে ইহঁতে প্ৰপোজিশন এডুকেশ্যন ফাইল কৰিছে
So statement doesn't need reserve complaint আছিল to 2560 Lordship got it, my lord.
No, our pages are not telling, so you just give me the
Well, this is a letter.
annexure.
Letter
Annexure
annexure A in the affidavit in position
Okay.
of dated 11/3/2025. It is very recent.
By the director.
By the respondent number 4, principal comes superintendent. সেইটো কথা ক'লে নেকি মই যে কৈ থকাটো এইটোতো বেলেগ মই যিটো ৱৰ্ক পেজ সেইটো আছে নেকি
Probably it will be page number 2515. Running page. Annexure A. Yes.
Annexure A.
I'm on that.
Yes.
It's a letter of 13th May, isn't it? 2020.
Yes. 13 May 2022.
Oh.
This is a letter written to the principal. Here, this is Assam advertisement number so and so dated 18/9/2022 regarding medical verification of PW candidates. With reference to the subject cited above, I would like to request you to constitute a medical board for the purpose of conducting medical verification of the PWD candidates who have applied and provisionally selected for the post of regular thesis under DE Assam against the advertisement for recruitment with a number under reference. A list of candidates provisionally selected in the final select list is enclosed here for your kind reference. You are requested to initiate the intimate the schedule of the medical examinations by the board well in advance so that advance notice can be issued to the candidates to appear before the medical examination. You are requested to intimate the schedule, yes. While constituting the medical board, you are requested to ensure that specialists to ascertain the benchmark disabilities are given in the medical board. You are requested to submit the report of the medical board after checking the genuineness of the disability of the candidate latest by 25/5/2022 so that the genuine candidates can be allowed to download their appointment letters and appropriate legal action can be initiated against the fraudulent candidates.
This is the subsequent advertisement, isn't it?
No. This is in our case. This
Your
is
case.
18/9/2022.
Because
আমারটা
here,
নয় না?
yours is
Subsequent.
Subsequent advertisement.
Subsequent.
18/9/2021,
This
isn't
is
it? Your
subsequent
case.
advertisement. Yes, right. Lordship is right.
About the tested
Hmm.
person where persons to complete recipient various corner the new site published.
Record দিছিলে।
এইটো আমাৰ দিছে হেৰিটো opposition
Hmm.
first opposition তাত দি গৈছে taking order 233
This is second. And here, কোনে দিছে এইখন? Director,
Elementary education.
এইটো কি হেৰি দিছিল নেকি?
Position of
ক'ত আছিল সেইটো?
in-person.
Yes, well, regarding, because I was trying to inform your lordship that they said that there was some information regarding form. Some information. This has been indicated in the letter, which was, that is, they called it a speaking order, which was issued on issued
29/7/22.
29/7/2022. They have annexed it in their affidavit in opposition, page 2339. হয়নে? এইবিলাক কোনে কৈছে?
Indian order, sir.
Huh? In the impugn order itself, this is the impugn order. In the impugn order itself, they indicated this.
In the opposition may also lordship check. It is page number 2339.
Affidavit in opposition filed by
Elementary education. Director.
By the
Elementary Director of Elementary
Director of Elementary Education, Suranjana Sanapati. We have also annexed this in our writ petition, also it is there.
Volume 8 of the June 231.
You can lollipop to lay here, mark.
Okay.
Here, lordship will see findings there.
Annexure, speaking order.
Yes.
Yes.
Annexure
speaking of-
C.
Yes, Annexure C.
Okay.
And this is Annexure 9 in our writ petition. The same thing is Annexure 9 in the writ petition. What it says, my lord, why they had to go for this? Findings, my lord. Whereas pursuant to complaints received from various corners and news items published in various newspapers about fake and fabricated PWD certificates, the principal GMCS Assam was requested, PD letter so-and-so, letter 13/5/22, that a medical board be constituted to verify the genuineness of the certificates of the candidate who have applied under PWD category. LPO. This is pursuant to complaint received from various corners and news items. Foundation is this, they want to say. What is the veracity of this thing? Something has come up in the newspaper or somewhere else and you will penalize in general. My full submission is, if somebody has, because the service rules also prescribe for it. If somebody has given any wrong information, made any misrepresentation, giving false information, have procured certain benefit, he can always be taken care of and he may be removed at any time. He can be removed at any time, anytime. They have not elaborated anything except saying this. In their affidavits, in opposition or additional affidavits, nowhere they have elaborated this. What complaint they received, from whom they received. Why authority was prompted to go for all that. And if they would have conceived of any such situation, they could have issued such notices beforehand. You cannot take everyone by surprise. These candidates cannot be taken by surprise. And just one fine morning, after completion of the whole process, one fine morning you say, sorry, you are out. You cannot be considered. Whether it would be fair. It is not the case of the authority that those certificates were issued not by the competent authority or that some certificates were not by the competent authority, or that some candidates were not at all visible. Thing. So fraud as such is not applicable. Then comes to this findings. Findings recorded by the competent authority is virtually supported by the subsequent medical board when they found 29 people eligible subsequently carrying the same percentage which was certified earlier. So how can one say that the medical board, first medical board, which was constituted, which nullified all of us, that report was genuine and that was authentic and sacrosanct? Because prima facie the records produced, therefrom nothing transpires that the process was done in a manner by following the entire process of testing to come to a conclusion. Nothing is indicated. This court's direction that individually you give the individual details of everyone on what ground you have rejected. Proceedings should be given. That has not come forth. Only that bunch of papers have come, which says in respect of availability. Well, fine. But it also doesn't contain those detailed reports. So, my respectful submission, they are trying hard to keep us out. But in my respectful submission, this honorable court will be pleased to direct them to take us back, to appoint us. We were not appointed. Vacancies were there. Interim order still. There was an interim order to my mind, I suppose.
Interim was there? Interim?
Interim order was there, I suppose. So, yes. No, not problem. Yes, but asıl then lage. What the bother cycle lego? Liana can have that. Meeting. So he took क्यों ना है कि
24/8/2022 order.
Sorry, Malak.
24/8/2022.
24/8/2022. There was an interim order, I can recollect.
There's no interim order.
Yeah.
But an undertaking was given by the advocate.
Oh, yes, yes, yes.
Just check up if you have a copy.
Yes.
You have a copy. Are you still keeping the vacancies?
But that the education will have to say, well, whether it was continued or not, well, till last 2 years, it will be difficult because subsequent to that, there were 2 advertisements. In 22 again, well, in 23 again. So probably what it was left out. Even then, well, that part will come, well, after hearing the other side. We'll have to make our submission too. And well, that commitment probably was for the till the next returnable date.
No. Says Mr. Saikia, the Advocate General Assam, submits that the vacancies would not be filled up immediately and without taking the leave of this court.
Yes, this was there. Lordship passed that order.
So in view of that, this court passed in that view of the matter.
No interim order.
No interim order is
necessary. Yes. So, my lord, so for the other two decisions are concerned, those are also have no applicability directly to our case. Our facts are different. The law laid down as such, fraud vitiates everything. I do not dispute it. But it has to be proved. It has to be pleaded specifically and it must be established so that one can be denied any kind of right he has. Otherwise, here the procedure adopted is arbitrary. On that very day, there was no power The notification they are relying is subsequent to. Therefore, the very action was not backed by any law, sending them for the medical examination. And subsequent examination also, my lord, one may argue that since you submitted, you were found ineligible, how can you now claim? If certain things are void ab initio, without power, without authority, then it remains void ab initio. My participation will not confer the right or power to the authority to do that. Do certain act, to take certain action, if otherwise law has prohibited it. Law has given this power to somebody else to do specific things. Therefore, my participation, and more particularly, I am in the receiving end. I am a job seeker. Advantage is sought to be taken upon me. How can I bargain with them? I do not have the bargaining power. I am genuine. My certificates are genuine. I am claiming. I have not procured it by foul means. And so, you cannot penalize me outright without giving me any opportunity of hearing, without taking me into confidence. And when your own action has proved it, my case is supported by your own inconsistent reports. That yes, at least some of them have been found fit. Therefore, my lord, my responsible submission is that Lordship will direct them to appoint us, give us the benefit of appointment, with condition that if at any point of time, if there is genuine specific allegations or informations that are against any of them, they can proceed and take action. They can take action. The Supreme Court has said in that case. Otherwise, you cannot penalize them. That's my responsible submission. There are keeping vacancies. There are vacancies. Now, today I got a message, got a news item that some 14,000 and odd two teachers are going to be filled up now within 2-3 months. There is not that posts are not there. That's why the learned advocate general made that submission. There is no doubt of post. We are there. We can accommodate. If the court clears it, we will do it. Therefore, it is there. Board is open. They can accommodate us. That's my responsible submission. I think I can conclude, my lord, here. They have given their part. They don't have any right to answer. But if they want to clarify 2-3 things, I own mine, my lord, they may do it with your lawsuit permission. I will leave. Deeply.
Yes. Otherwise, also like this. Huh? Oh. Yes, Google.
Our part, my lord, along with the education department, can it be day after tomorrow? It will be concluded.
Yeah. At Mr. K.K. Manda, then a senior counsel assisted by MS N. Begum and counsel. On request made by B. Gogol and Health and Family Welfare Department. This the matter again on. Day after tomorrow is what?
It is my lord, 20th of March.
20 March as March 30.
Let's say we are at number 24 to 27. That is another matter. Let's say, unfortunately, it could not reach. It's a part of matter regarding the pensionary benefit of the. Can it be time will not will permit to do
on 20th, Thursday at 2 p.m. Lordship, I will take I will also get a return argument on that there also to for a 20 and 2 p.m. Lordship. Thursday 2 p.m.
About 25, that will be better, I think. I think that they lesser cases are there.
Thursday 20 20
25 করো দাদা
not 25 or more.
আগর কেস 20 ফিক্স হলো আগর কেস দীঘলে চলিব কেন
25th there is another part hard matter.
No, 20th we have another part of 20 we have another part of the one which is going on right now. So that will again take us.
You'll take some time, Majumdar. In that today's part,
Yes.
How long you'll take?
Two of us together, we should be finishing around 1.5 months.
25th and my friend, I said 25th. 27. Then you do take it 27. 25th another part hard matter. Where is fixed and got it.
27.
Yeah, code number 10.
And request made by the parties.
20 at 2.
We'll see,
Okay.
sometimes it reaches early also, better not.
Item number 6 and 7, my lord. Here
Yeah.
petitioner is a MSME unit, my lord. Petitioner is an MSME unit, my lord. There are some dues, rental dues, which are supposed to be paid by the respondent, my lord. Pleadings are completed, my lord. Can it be taken up on 27, my lord?
Okay, you are for the petitioner?
I'm for the petitioner, my lord. For item 6 and 7.
Okay, on request made by Mr.
Yes, Hazarika.
S. Hazarika. Your name is not here.
On behalf of my lord B. Kaushik, my lord.
Okay. 6 and 7.
6 and 7.
It will be separate orders, sir. Learned counsel for, on request made on behalf of B. Kaushik. Learned counsel for petitioner. This down. When do you want?
27, my lord.
27.
I am deeply.
Any other matters?